Help! I've been tossed overboard.
I'll have to bill you extra for my time.
Welcome to the show. You look incredible, like a dessert that owns a yacht.
That's exactly the vibe I was going for. You know, sweet but slightly out of your tax bracket.
Mission accomplished. How does one even shop for a suit when your head is...
Gold on my neck, gold on my hand. Purple with the stripes, that's the walk of a man. Sidewalk shining, city lights humming. Every step I take, they know a boss is coming.
Police or zombie problems? Your tortoise won't stop breakdancing?
Try blue tape.
The miracle of our age. Yeah! Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem under the name ThATuMBRELLAgUY. I sent him my phone number at least 20 times in the chat. And told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. Told him to call me.
You know what? I talk to your man.
Mask on. Lights low. Size 14.
They were selling me a Halo. Hands deep in the payroll. PR wolves in the raincoat, calling it a campaign. Same old 100K in the smokestack. Trust us will bring hope back. Every post was a blowback to the screenshots. Hit the group chat. Career crooks in a PR suit. One donor, paid the whole loot. 56 in a quick swoop. Left them hollow as a dry root. Timeline turning into siren. Every threat another siren. Can you feel the floor sliding? Yeah, we see where you're hiding.
Master.
Pulling down the curtains, receipts in my hand, now it's certain. You were out here grifting for the cloud and the cut. Now the whole feed watching while we're lining you up. Masked up, every line replay. Name in the tag, can't escape that display. You can scrub, you can spin, you can cry, that's enough. But the internet remembers and it's looking real rough. Yeah, that umbrella guy drop links. Suddenly your bravado shrinks. Every don't ass start to stink. When the totals never match the ink. Yeah, you were bragging in the group chat. Same time begging for a new stat. Talking justice in the hashtags. As you laughed about the cash grab, you said trust the plan. Now what? We just mapped every dime, every cut, every alt, every sock, every front. Funny how the math slips in a stunt. Is it fraud? Is it cloud? Is it both? Is it law on your neck, on your throat? You could claim it's a game, it's a joke, but a lot of people broke when you spoke. Masked up, pulling down the curtains, receipts in my hand, I was certain. You were out here grifting for the cloud and the cut. Now the whole feed watching while we're lining you up. Masked up, every line on replay. Name in the tag, can't escape that display. You can scrub, you can spin, you can cry, that's enough. But the internet remembers and it's looking real rough. Screens glow, ain't scroll. Mask on.
What's up, folks? Early Sunday streaming. Actually, we have to go early on today to get through one of those documents. It's so freaking much. But it's good stuff, man. It's all good stuff. Apologies for yesterday. We had power blinkages a few times, and I was like, I am not fighting this all day. So I ended up just calling it a day yesterday. Felt really weird too. I wasn't planning that, but that's the way it goes, isn't it? I hope everybody's having a fantastic day today. By the way, again, welcome to a brand new month. We're kicking off March now. God, we actually have we have the protective order. That hearing stuff's coming up pretty soon. You'll have the second portion of that. Lord, you also have more and more stuff that is going on with the entire the bankruptcy mess. And it's funny when you look at the whole ecosystem response to it, they seem a little bit stressed about it. Mark, props to you for putting the stuff up, by the way. I like these little segments here. It's funny if you read through it. Oh man, the fact, first of all, they're butthurt. They're like, oh my God, we'll put Tug's bankruptcies up. Okay. Why don't we do that? Why don't we do that? Again, it's pretty funny to me when these people. I thought bankruptcy was the miracle cure for all of Lynette Preston's problems, and now suddenly, oh my God, maybe we can silence people from talking about them. Isn't it strange how that works? Very strange indeed. When you get down to it too, the interesting thing is they keep saying things like this. These are direct quotes, by the way. If you read between the lines, Meghan is hoping large sums of money may have changed hands to lead directly to Michelle. Some officials looked at not. This is the facts, by the way. Sorry, hate to disappoint you, Meghan, because nothing's changed hands. Nothing in Michelle's name. Nothing came in Michelle's name. Nothing whatsoever. Now, the weird thing is, we kept receipts all the way back. And I kind of love that because you remember when everything popped off with Only Me? You remember when the arguments came up? Well, there were a few smoking gun comments that came up then. Like one of my favorites, again, is this one. Here, you have them arguing with Only Me in one of the chats, and she says the $56,000, the 56K, was not just for the barn. It was for the fence. It was for Holly. It was for really Harley Jolly. I keep saying Holly almost. I'm saying Harley, but it's not coming out. Harley Jolly Christmas and the barn. Now, who does all of that have in common? Who owns the fence? Who is the barn for? Whose child is H? Weird, isn't it? You also have all of those comments that came from that certain donor that they really are. I'm turning all this stuff over, by the way. I've already started turning it all over just to make sure. Oh yeah, you think you won't run into your own fucking words? Believe you me, I know what streams these came from. I know when. I archived the shit out of this stuff because I knew at some point it would either be. I didn't think it would be a bankruptcy that we would be seeing this in. I actually thought it would be something criminal. But you have a guy again. He is under the impression when you go through, I'm not showing a million of these, but he's making statements like, so when someone donates over 56,000 for a family, that's weird, right? When the guy donating it off thinks that he's donating. Oh, look at this. It wasn't for the Prestons, huh? Well, that's weird because the guy who donated $56,000 thought it was. Answer the question. It's not rocket science. Only me donated $56,000 for the Prestons. Yet she said she needs more money. Weird, isn't it? And of course, the coup de grace, as it were. You have only me again, just noting this stuff since they are bringing it up. They always are trying to respin this, but I mean, I'm telling you, they seem very panicked about this. I mean, you had David there. Again, he put out his own list of numbers. They put up receipts for where money was actually received, where they were trying to deflect. So there's no way that those courts are not going to look at that. Plus, I mean, we have Michelle Preston, where she decided to talk to myself, talking about money. I mean, it's all there. So to pretend that there's no proof is utterly insane. Now, another thing that I thought was kind of interesting with all of this mess, and today, by the way, the point to today, I really want to go over just a note. Give me a second here. I'm opening it up so you can see it. You remember there was a 70-page filing, 70 freaking pages for the magistrates, the objection to the magistrate's report and recommendation. I kind of want to cover that today. I want to cover it all today. So we will do that in just a minute. And there was also a John Cook filing that was also placed into this this mess in the last week. We didn't actually hit to. So I thought we could, let's see, I'll show you. Give me 1 minute here. I'm going to lock them both in. So you have, again, this, which is 70 pages. It is a massive filing. We read some of it, but man, it is a massive filing. And I think it's worth looking at just to see exactly what the arguments are and to really, clarify some of that there. And then you had John Cook's filing too. There was so much that hit last week. I mean, that doesn't even count like streams or anything going over any of it. One of the things, though, that I think is worth discussing too, they brought up as well, was the whole thing about Travis. They actually brought that up, not just Travis, but Levi's mom. That whole incident, they actually brought that up. Now, if you don't know what this is about, by the way, I'm of the opinion, reading through this, they actually admit to something in here that's, two things that are kind of fascinating. Number one, they admit that Michelle Preston going after the woman at the trading post, their kids, they're admitting that Michelle Preston may have not realized whose parent, whose kid was who. So they may have thought they were going after another kid's parent instead. So with the confusion with Travis about the whole fireworks ordeal. So if you missed out on this really quickly, you had Travis, he was on a live stream, and there was a minor on the live stream as well. He was getting super chats. Every time they got a super chat, they would throw a firework. And every time a firework was thrown, just a little extra something celebration. Well, apparently Michelle Preston called the police. The 911 call is on Shara's channel if you want to check that out. If you haven't seen it, you definitely should, just to really, just to see. And there's body cam and stuff as well. But, and there's Michelle Preston giving the double bird salute to the police, just to note that too. But apparently when she did this, she didn't know what kid she was taking aim at. Apparently she may have gotten confused. And that's why the whole trading post, that came in. Now, I kind of hate that for the parent, the way this comes up. Just listen to some of this mess. I mean, so He has a chat, talking about Travis. He has a chat on the channel with Levi's mom, the lady from the Trading Post. Yes, I know who she is, because people are insinuating that Travis shouldn't spend time with Levi. That would be the lady's son and not the one on the video, just to make that clear. She also says she's not interested in any of the what the hell's crap. She's not. She's absolutely not. And she didn't want her kid involved in any of it. She told me that herself. He did an interview with her that I saw that people are claiming the PDF file thing with Travis and the kids. And she wanted to come on and say how thankful she was to Travis because he helps, spends time with Levi, and Levi loves him. All the people, all this insinuating crap is just crap. Well, I don't know about that. Yeah, of course, they start up nasty freaking things, and then after the mom has to come down and try to put that to rest, they're like, "Oh, I don't know anything about that." Stupid morons. I don't know anything about that PDF thing, but I know that she told me she didn't want him involved in any of the what the hell shit all on video. She told me that a long time ago when I bought that countertop for Michelle. Okay, well, there's one admission that is straight up. So as far as Trading Post, yeah, you know where that where those dollar reviews came from. But that's where I got it. So that much, but I think that the PDF thing isn't so much about that kid. I think it's about the other one, the one with the mask. Wait, what? Are you calling the guy a PDF file because he's nice to kids that live in the nowhere and they actually need some people to be around? Huh, that's weird. That's weird. These spoken like people who destroy other folks' lives with false accusations. Isn't that the way it is? Isn't that the way? But they go through, and through all of this stuff, again, they try to pretend that they're not calling someone a PDF file. Well, calling someone a PDF file, isn't that messed up? Oh man, that's awful, Cynic, dude. Yeah, prayers for you, brother. Prayers for you, my friend. And your family. That's awful, man. We just had so I had this is crazy. One of my cousins that lives in this area that is known everywhere here. He does a lot of the historical stuff here and just known by everyone. He's worked with Walmart for 34 years. This guy has, and he didn't come to work the other day. So everybody there kind of, they were like, what the heck? Because he never misses ever. So his work colleague sent somebody over to his house and they found him in the bathroom floor unconscious. He had a brain tumor. And they took him from here to Murfreesboro. They said that, if you catch it within X amount of time, it's a lot better chance for recuperation. So he ended up having surgery on that and he's doing good so far. But man, it's crazy how life comes out of nowhere. So man, I hate that for you, brother. I do. We will definitely keep you in prayers as well. Cynic in chief. Confirm the antis are not PDF files. They hate kids. Yeah, well, they see them as a form of currency they can manipulate and use. That's for damn sure. They're like, well, put the bullseye on those. Now let's look at the John Cook filing real quick. And then after that, we will hit this big long filing. I think that one's a pretty good one to look at. So John Cook. Now this this stinks of Bruce. This sounds like a lot of Bruce. These are either Bruce words or, well, I mean, again, might be his attempt at something. And it's funny because they bring up the judge grudge. in comparison with trying to remove the magistrate. Boletho, what they don't tell you in with the Judge Craig ThATuMBRELLAgUY, is that he was removed. He actually was taken off. So if you see parallels in that John Cook or Bruce or whoever the fuck is writing this stuff right here, then maybe you should ask yourself. Now, again, the antis have been doing a lot, and I do mean a lot, of bending over backwards trying to defend ThATuMBRELLAgUy. It's amazing. It's amazing. They'll defend any corrupt fucking garbage. Doesn't matter like what it is, how it comes together. You know, they in fact, here is them defending. Give me 1 second. I've actually got a few of those screenshots where they're defending Hale grudge judge, you know. Now, excuse a little blurry because I'm blowing it up all the way there. But Florida law says a judge can't respond to the charge itself, but the motion only. ThATuMBRELLAgUy gave a reason why he made the decisions he did. So it's automatic. Yeah, no, Marla. No. That's not. Good Lord. You could read the actual freaking order. And I feel like these people just make up random shit all the time. Oh, my God. Oh, yeah. The minute ThATuMBRELLAgUy ruled in Michelle's favor, he was the worst judge. It's a pattern the courts will see. Well, you know, ThATuMBRELLAgUy, again, was removed, you know. He doesn't like strong women like me and Lisa. You know what's funny? Lynette Preston is out here running her fucking mouth about Jeremy Hales still. I mean, she's in the middle of, God, you would think that her lawyer in Ohio would be like, shut up, Michelle. Shut up. Every day. All of it. And she's like, oh, that's stalking. What a bunch of idiots. But they go out of their way to try to, look, she says things like, too, this all started because they set eyes on my child. What? Remember, like that could definitely be taken as some pretty awful claims, you know, some pretty awful stuff. You know, the PDF file claims. Yeah, you see where I would loop this one in there too. I would. I'd be like, all right. So you say that they're trying to steal your kid and then they've got eyes on your kid. And you made all these other claims. Gross, man. Again, these people, and it goes on from there. I don't want to spend all day going through your stupid freaking statements, but God, these people. All right, here, let's go back to that filing. So, defendant Cook's response to motion to disqualify the magistrate. You know how you know that this isn't John Cook writing? Because John Cook would probably have to write it in crayon. That's what he did. Oh, my God. Because magistrate isn't spelled like maggot straight or something. There is no way in hell he wrote any of this. Request to show cause a report to the Florida bar. This is my response to the plaintiff's motion to disqualify the magistrate, which they said in Doc 166 and the other case, quote unquote, is being filed in both cases. Yes, that's how it would work. You would be disqualified in both. If he's disqualified in one, he would be disqualified in both. That is not rocket science anyway. Holy God. Defendant Cook states that he opposes the motion to disqualify. They're creating sensational storylines for YouTube content they will make from it. Again, these kind of statements here with nothing but that, this kind of stuff is the thing that the judge should have been striking after a while. He told them that he was tired of this, but you notice he's never done anything about it, ever. They continue to say this same blah, blah storyline. You know, meanwhile, they seem pretty interested in going on YouTube and talking about things too, huh? Kind of strange how that works, right? And they made a lot from it too. When people are providing them not just with flea market, but managing to stock the entire thing for them, they're providing them with merchandise, and apparently with they're paying for the place at the trading post. There's a lot more in that too. This stuff, it's interesting, isn't it? But they did the same thing in Levy County Court with Judge ThATuMBRELLAgUY in 2024 with the storyline deemed Judge Grudge. Many other YouTube channels make content from that and will from this as well. Fucking Hale made content from it. The thing they left out, like I said, is the fact that an appeals court actually agreed with that. So I don't believe that is something that was just made up for YouTube content. If it was just made up for YouTube content, an appeals court would never agree with you on it. Additionally, I request that the court issue an order to show cause. Why? Attorney Shockett should not be found to have suborned the perjury contained in paragraph 19. My God, Bruce, are you still trying this one? Of document 8-1 or Cook requests the court simply refer to the matter to the Florida Bar for investigation into whether Attorney Shockett suborned perjury. Attached here is a letter from the Florida Bar informing my former counsel. You notice, here's your little clue there. Informing Bruce, that because it was part of litigation, they would not investigate whether Attorney Shockett suborned perjury unless the court took some action. That's what they say. Again, we've noted that a million times. Isn't it weird that the things that they get in trouble, with unlicensed practice of law. They get in trouble for other stuff. Well, I shouldn't say in trouble. They seem to have dodged any type of consequences for the things they were supposed to be in trouble with the other stuff too. But isn't it interesting? These same people are like, meanwhile, I'm riding the bar. This is what Bruce does. This is what these wonderful officers of the court do. This seems to be what every one of these ecosystem lawyers, past and present, has managed to do. They have all targeted people. But the letter, thank you for your recent correspondence to the Florida Bar, wherein you allege that Mr. Shockett suborned perjury in the underlying civil matter. The Florida Bar's grievance system is not a parallel forum for litigating the merits of statements made or evidence offered in the underlying case. Exactly. So what they're telling them is, hey, we're not here to decide whether or not any of these claims have merit. What evidence is offered to discuss that? We're not here to do that. That's not our function. If the court of competent jurisdiction ultimately makes a specific finding that Mr. Shockett knowingly misrepresented facts or otherwise commits some kind of professional misconduct, you may resubmit your inquiry along with a copy of such findings or orders. At this point, the bar would be in a position to further address the issue. What they're saying here is they're not saying that, oh, the court, we want something from them. No, it's saying, hey, unless the court actually did something in this, tough shit, you're out of luck. That's what they're saying. The plaintiff's statement that, quote unquote, online post calling him a certain type of predator ongoing continued to this day were fabricated in response to a 12B1 motion. It was not in the complaint and has never been added by amendment. Attorney Shocking could have confirmed the existence. This is such garbage. Again, you saw him. I just gave you another quote of oh, they said eyes on my baby. Again, what are they saying about somebody? What would a reasonable person interpret that as? See, they like to play this game here where they're like, we didn't actually say the word. Oh, Lord. It's funny because these are the same folks that, well, ask Paint Chips. He has a court case going on where he says that being called a PDF file was the worst thing that can happen. I agree that is a terrible thing, by the way, when somebody is it's called a PDF file, and there are many ways to do that. But these people, they're like, oh, he didn't say the exact word. He didn't say a child predator. Therefore, it's all good. It's perjury. These people kill me with this. This is such a hate boner here, though. I mean, I've never seen one just like this. It was not in the complaint, never been added. Attorney Shockey could have confirmed the existence of the supposed online post described in paragraph 19. If they ever existed, he knew none existed, but submitted the perjured affidavit to influence the court's decision to exercise jurisdiction. You know what's not happened to? Discovery. They keep demanding discovery before discovery has happened. Now, meanwhile, they refuse to turn over anything for their portion with discovery and Fit 1. But, I mean, it's unreal. The court explicitly relied on the perjured statement. The court was defrauded. If the court does not wish to address this matter, it should ask the Florida bar to look into it. Does this have anything to do, by the way, when they're asked, they're saying, hey, as far as a response to this, see, this is supposedly a response to the motion to disqualify the magistrate. Does this have anything to do with it, really? See, this is the kind of bullshit that this court has allowed to continue. You have filings that are grossly inappropriate, and yet they leave them on the record many a time, or they do nothing. They're just like, oh, well, not a big deal. Even after they've been like, you will not file this anymore. I guarantee you, if Shocking files some crazy bullshit like this, we definitely hear about it. But notice nothing happens. Now, this is a long filing right here. We're going to pull up. It's a good discussion about now, this assumes that you looked at the recommendations from the judge. And we did go over the entire document with recommendations. It was a 45-page document. Megan and myself, we went over it, which is quite crazy when you think about it. We managed a 45 and a 34-page document. That's pretty amazing, I have to say. Now, again, we've seen a portion of this. So when we hit that portion, I think I'll skim it for themes just to show. Well, I will see when we get there. Okay. Well, we'll see how it goes. So here we go. Objection to magistrate judge's report and recommendation. So again, this is Jeremy Hales, Elephant Shoe LLC, aka What the Hales, respectfully objecting to the report recommendation from Belitho, dated February the 10th, 2026, which recommends granting the defendant's motion to dismiss and dismissing all claims with prejudice. The magistrate judge erred in several significant respects that warrant rejection of the reports and recommendation and denial of defendant's motion to dismiss, alternatively, dismissal without prejudice with leave to amend. So one or the other, either, again, saying, hey, either we need to knock this outright, or you need to change this, the with prejudice, which is pretty damn extreme, and to change it to without prejudice with leave to amend. So you could go in, and if you want to amend it, refile, then you should be able to. So the standard of review here. This court must review de novo any part of the R&R to which specific objections are made. The USCS Federal Rules of Civil Procedure, Rule 72, the court, quote, may accept, reject, or modify the recommended disposition, receive further evidence, or return the matter to the magistrate judge with instructions. This objection is timely filed within the 14-day period specified within the R&R notice section. Yeah, remember that too. You have 14 days from when that comes in to actually file any type of objection. So the objections. Objection 1. The magistrate judge erred in analyzing the FDUPTA claim against defendant Lisa Lee. So the magistrate judge erroneously concluded that plaintiff failed to plausibly allege, quote unquote, actual damages and consumer injury under the Florida Deceptive and Unfair Trade Practices Act, otherwise known as FDUPTA. First, the magistrate judge incorrectly applied an overly restrictive definition of quote unquote actual damages under FDUPTA. This is because while the magistrate judge stated that actual damages is limited to quote the difference in market value of the product or service and the condition in which it was delivered. Actually, let me shift the screen. Give me 1 second here. Let me do it this way. I like that better. Sorry. I was looking at that. I was like, well, I like it this way better. So it's limited to the difference in market value of the product or service and the condition in which it was delivered and its market value in the condition in which it should have been delivered. Now, this is a narrow interpretation that fails to account for broader remedial purpose of FDUPTA in cases involving unfair competition between business competitors, such as this case. The magistrate judge defines the phrase actual damages for FDUPTA purposes does not include consequential damages or lost profits, citing a 2017 Southern District of Florida omnibus order. And he goes through the order here. Okay, now, a corporate competitor plaintiff may seek lost profit damages under the FDUPTA. However, in 2021, so he quoted a 2017 order, they're noting. However, under 2021, the Southern District of Florida stated, quote, the courts join other federal district courts in holding a corporate competitor plaintiff may seek lost profit damages under the FDUPTA. Again, case here. This shows the magistrate judge's analysis of FDUPTA claim is clearly erroneous. It notes, here's a heck of a footnote, by the way. Whereas here, the claim does not involve any breach of contract, warranty, or similar wrong sounding in contract. Any line drawing between expectancy and consequential damages is rather inapt. In case, quoting, damages for tort arising out of contracts are governed by the same rules as in the case of contract actions. The above principles suggest a much larger universe of damages available in FDUPTA claims arising outside of consumer transaction context. In case, describing the breadth of compensatory damages available under Florida law in tort case, especially when considered alongside the liberal construction courts must afford the FDUPTA to accomplish its remedial purpose. It makes considerable sense to permit a corporate competitor plaintiff to seek lost profit damages where there is no transaction, giving rise to the oft-used expectancy measure of damages. So in this, remember in his analysis of it, he was saying that you cannot seek lost profits under. And again, the argument that is being added here is saying, well, you quoted something from 2017. However, 5 years later, there was a different ruling. So you may have missed that. So plaintiffs failed, quote, to plausibly allege actual damages caused by lease-a-lease violation of the FDUPTA. Plaintiff's claims are ill-suited for the requirements of FDUPTA because, quote, this case does not involve a product or service, much less the delivery of that product or service in a manner that was not contemplated under a contract. See, it's very strange to talk about how, again, as we've talked about interpretations, especially in this ever-changing landscape that we have going on now, how either the law lags behind and it's inadequate, or judges' understanding of what constitutes something under the law, it severely lags. One or the other. That's where you do run into some major problems. Now with this, again, we'll see how they analyze that, but that has been a problem for quite a few things. Now, the allegations, 3, in the second amended complaint provide no basis for determining that actual damages, as a phrase has been interpreted for FDUPTA purposes, were caused by defendants Lee's alleged conduct. And 4, plaintiffs' claims they are entitled to $959,000 in damages from alleged FDUPTA violations, but the second amended complaint fails to explain how that amount constituted, quote, the difference in market value of product or service in the condition in which it was delivered and its market value in the condition in which it should have been delivered according to the contract of the parties. Accordingly, the FDUPTA damages claims against defendant Lee and count 2 should be dismissed. Now, all the above conclusions are erroneous because they are all drawn from a narrow interpretation that fails to account for a broader remedial purpose of FDUPTA in cases involving unfair competition between 2 competitors. Footnote. The Middle District, quote, agrees with the Timar court's reasoning and with the determination reached by the other courts in the Middle District of Florida, where a party brings a FDUPTA claim against a corporate competitor, as here the aggrieved party may seek past lost profits damages under FDUPTA. And again, you can see where this is laid out here. They note that in this, he relied on the magistrate judge claiming there is a sole permissible measure under FDUPTA. In any event, the Southern District has now clearly rejected the narrow interpretation of the opinion that was relied on in Judge Bolitho's reports and recommendations. Again, they're noting his was way too narrow. He didn't take into account everything that was out there. He missed something and something major. So therefore, the court should reject the above findings clearly erroneous or misapplying a controlling law and instead find that plaintiffs plausibly alleged actual damages and consumer injury under Florida's Deceptive and Unfair Trade Practices Act. Second, regarding injunctive relief sought by plaintiffs, the magistrate judge erred in concluding the plaintiffs failed to plausibly allege consumer injury. The second amended complaint specifically alleges that defendant Lee solicited cash from consumers who watched her programming and misled them to believe these donations were for a charitable purpose, when in fact Lee kept the bulk of the money for herself and for her own personal use. These allegations, they clearly establish that consumers were aggrieved by Lee's deceptive practices as they were induced to part with money under false pretenses. The magistrate judge's conclusion that, quote, the allegations in the Second Amended complaint are not aimed at vindicating consumers who were harmed by defendant Lee's conduct directly contradicts the explicit allegations in the complaint that Lee's scheme was nothing more than a scheme to enrich herself at the expense of consumers and Hales. Therefore, the court should reject the above finding as clearly erroneous or misapplying controlling law and instead find the plaintiff's allegations clearly establish that customers were aggrieved by Lee's deceptive practices as they were induced to part with money under false pretenses and were aimed at vindicating customers who I say customers. Sometimes I'll say customer instead of consumer. You'll have to forgive me if that's the only thing that I throw off today. I've done very well, in my opinion. Who were harmed by defendant Lee's conduct. Now, objection 2. The magistrate judge erred in analyzing the Lanham Act claims. So the magistrate judge erred in dismissing plaintiff's Lanham Act claims by misapplying the legal standard for claims under 15 U.S.C. 1125A. The Lanham Act is codified by, again, 15 U.S.C. and is commonly known as Section 43A. The Supreme Court has clarified that Section 43A is not a general catch-all statute covering all deceptive trade practices. Instead, Section 43A, quote, creates two distinct bases of liability. You have false association and false advertising. Now, the R&R, it states, quote, in count 3 of the Second Amended complaint, plaintiffs claim that defendant Lee violates Section 32 and 43A of the Lanham Act. However, this paragraph is the only time the complaint references 1125A 1A, Section 32, and as a result is, so here, this is an error. So under that, that's interesting. So they're noting, essentially, if you look at this and what it notes here, there is essentially a typo in that. And the judge hammers this and hammers it, which is interesting because that makes something that came up in this make a lot more sense now. Let me see. The idea, we'll read through this. So essentially, though, they had an error in that. This is because a plain reading of plaintiff's complaint shows that his gravamen and substance is false advertising as a distinct basis for liability, as opposed to false association, and thus the type of claim plaintiff asserts. So, in the reading here, because there is an error, the judge, it's noting, didn't take in the substance of the reading itself, which if you look at law filings, the amount of freaking typos, I mean, my God, you're talking about some pretty lengthy documents sometimes. So you do get some typos in it, but it's noted you're supposed to take in the document as a whole, what it's discussing. And it's saying that there was a typo or, there was an error. I'm using typo because that'd probably be the best way to describe what they're saying. And that it's not, they weren't talking about false association. They're talking about false advertising as a distinct basis for liability. Now they say, see blah, blah, blah here. Lee and all defendants agree to intentionally participate in a civil conspiracy amongst themselves and with other individuals for the purpose of which was to commit violations under FDUPTA and false advertising under the Lanham Act, 15 U.S.C. 1125A, and the tort of tortious interference with advantageous business relationships. Also, the complaint states, quote, YouTube's main source of revenue is advertising, which enables businesses to find relevant audiences and grow their businesses and brands via unique YouTube channel platforms for a business. Creators who are part of the YouTube Partner Program are eligible to share in advertising revenue. Hales is part of the YouTube Partner Program with a current YouTube subscriber fan base of over 730,000 people from across the world for the YouTube channel What the Hales. Now, case law demonstrating that a complaint must be evaluated based on its substance rather than its form. Quote, in determining the presence of a federal question, the court looks at the substance, not the labels, of the plaintiff's claims as contained in the factual basis in the complaint. Now, the 11th Circuit has also approved the practice of recharacterizing filings based on the substance and the type of relief sought. For example, in here, the court recharacterized a 1983 complaint as a 28 USCS 2241 petition based on the substance of the claims and relief sought rather than the form of the filing, holding that, quote, the 11th Circuit has approved the practice of looking past the title of a submission or the form on which a claim is made and recharacterizing a filing based on substance and the type of relief sought. Give me 1 second. I lost the chat. Good Lord, my chat is lagged out. Give me 1 minute. I lost you guys. What annoyance. 1 minute. There we go. It lagged out all the way. I watch you all on my phone. I was like, wait a minute, it hasn't moved for a minute. That's also how I tell if like I like have a lag out or my broadcast stops or something. I watch you guys and I may not, when I'm reading, I may not catch it for a minute or two, but I was like, wait a minute, the chat's not updating. Now I can see, hey Shane, what's hey there indeed. So here, I'm going to start this sentence over. Okay? The 11th Circuit has approved the practice of looking past the title of a submission or a form on which a claim is made and recharacterizing a filing based on the substance and the type of relief sought. Again, case law, implicitly approving action of a district court recharacterizing the 1983 complaint as a habeas petition based on the type of relief sought. The first time I ever saw habeas, by the way, it enunciates the same way. I never, for some reason, mentally, I never pictured the wording, like how it's written out. I never pictured it spelled that way. But also with other case law, recharacterizing 1983 complaint as a 2241 petition, where state pretrial detainee sought to force state to honor his right to a speedy trial. A report and recommendation adopted consistent with the approved practice. So this means that plaintiffs' counts regarding the Lanham Act based on the substance are about false advertising unfair competition, which covers misrepresentations as to the nature, characteristics, qualities, or geographic origin of goods, services, commercial activities under 15 USC 1125 1B. So does it note? Just give me a second. I'm looking at something here. I'm curious about where so did they note it as 1A? Is that what the issue was? 1125 1A. I think they, so instead of instead of going with, you have two distinct portions of it, one A, one B. They had an error, a typo, and where they put in they put in like A instead of B. And again, this judge seems only on one side of it, mind you, but this judge seems to love to hammer the idea that, there's a typo. Now, it's funny how that you remember in Fed 1 where they brought up the idea that Bruce could be making up his sources. And they noted that. You notice that never came up, by the way, because there was never a Bruce there to talk to. You notice that when pro se litigants file something, there's never a discussion over it, my lord. It does have some commonality with another judge that we saw. A little bit more than I thought of at first, huh? But which provides the cause of action against false or misleading statement made in commercial advertising or promotion. The R&R concludes plaintiff's cause of action for false advertising, unfair competition is also subject to dismissal. In doing so, the magistrate erred in concluding that Lisa Lee's statements were not commercial speech. The Lanham Act applies to commercial speech, which includes speech that does no more than propose a commercial transaction. The second amended complaint alleges that Lee is, quote, a competitor of Hales for internet sales and marketing, who operates her own YouTube channel and other social media platforms where she solicits and accepts tips and donations from viewers. Oh, yes, it's about trademark. Let me see. Where is that? I missed this. Yeah. So when it notes here, he brings up the word trademark over and over again. Like that was brought up when we read over that, did you notice that word kept coming up? Trademark, 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 trademark. And it was like, this isn't a case involving trademark. Like why is that coming up over and over again? And it's because of that error. That's why. So we got hyper focus on trademark. In fact, the word trademark does not even appear in the second amended complaint, yet I'm just going to call them the recommendation. In the recommendations, 16 times. So they're saying when you look at the entirety of what was stated here, this error, they focus on that instead of the substance. And you could clearly define that it wasn't about this A portion, it was about B portion. But because of this typo here, if nothing else, you would think you would have the ability to go in with an argument like that and potentially amend your complaint. Here, the court must accept all factual allegations in the complaint as true and draw all reasonable inferences in favor of the plaintiff. That is indeed true as well. When they look through something, if you've never heard this, remember, in review, they must review all allegations in a light most favorable to the plaintiff. So they look at it and they consider it and they think, well, if all of this were true, then that's the way they're supposed to review. Sometimes when you look at cases and when they're kicked as well, you can clearly see that they have not done that. And yet, but Lee's false statements about the plaintiff were made in the commercial context to divert viewers and revenue from the plaintiffs to herself, which constitutes commercial speech under the Lanham Act. Wait. Palm Wonderful? Are you talking about that? The pomegranate juice? So Palm Wonderful and Coca-Cola? I haven't even read that one. Oh, by the way, this is random, but I do want to bring this up. You remember those 4 college kids that were killed? It was huge headlines. There was a TikToker. This is random. It just hit me and I'm going to forget. That's why I want to note this. There was a TikTok psychic, I guess is what they called themselves. They came out and said that there was a college professor that had a relationship with one of these people, and also claimed that they were part of the conspiracy to end these people's lives. Well, that's the case with Kohlberger, by the way, the Moscow murders. Well, there was there was a lawsuit over those claims, and the TikTok psychic ended up getting hit for $10 million because of those claims. The false statements about people made me think of that for some reason. That just came in like that was a few days ago. But it was so crazy because, you know, this person without any evidence whatsoever came out, accused somebody of being a conspirator, or really the mastermind. I shouldn't say conspirator, the mastermind in a plot to end 4 people. And I mean, blasted all over the internet. And the person they were accusing went, I mean, they bent over backwards, being like, you know, they served them the cease and desist. They asked them, hey, all we want is a retraction of this. And now they're on the line for $10 million. Crazy, isn't it? But the false the false statements made me think of that. So anyway, Palm Wonderful versus Coca-Cola, and the Lanham Act creates a cause of action for unfair competition through misleading advertising or labeling. Though in the end, consumers also benefit from the act's proper enforcement, the cause of action is for competitors, not consumers. The term competitor is used in this opinion to indicate all those within the class of persons or entities protected by the Lanham Act. Competitors are within the class that may invoke the Lanham Act because they may suffer, quote, an injury to a commercial interest in sales or business reputation, approximately caused by a defendant's misrepresentations. The 11th Circuit has adopted the widely accepted 4-part test in determining whether speech constitutes, quote, commercial advertising or promotion under the Lanham Act. So, to be part of the under the Lanham Act, one second. My mom's calling me. I'm gonna see. Give me 1 second. I'm gonna make sure everything's okay. Yeah. 1 second. Hey, on stream, everything okay? Just give me 1 second. I'm just making sure. My mom, when I call, I always like to make sure she's doing okay, and it's not just a random call, you know. But the 4-part test: speech much. Number 1, be commercial in nature. 2, be made by a defendant in a commercial competition with the plaintiff. 3, be intended to influence consumers to purchase the defendant's goods or services. And 4, be sufficiently disseminated to the relevant purchasing public to qualify as advertising or promotion within the industry. Now, this test ensures that false statements made with the intent to divert business from a competitor are actionable under the Lanham Act. The nature of the inquiry, what in the world? Inquiry under the 4-prong, whether the representations were sufficiently disseminated, is fact-intensive. Courts have recognized that this element typically requires an analysis of the breadth and scope of dissemination, which is not suitable for resolution at the motion to dismiss stage without a developed factual record. So they're saying, hey, you know, at this specific stage, you can't really answer whether or not that has been noted. For example, this case here, the court noted that whether a false statement was sufficiently disseminated is, quote, ordinarily a question of fact inappropriate for resolution on a motion to dismiss. Similarly, Another case, the court inferred sufficient dissemination based on allegations of systematic targeting, but emphasized that evidence would be required at later stages of litigation. What constitutes sufficient public dissemination of an alleged misrepresentation, quote, varies from industry to industry and from case to case. 7-Up. 7-Up company. I like seeing who's suing her. While, quote, merely isolated individual statements of opinion by single sale representatives to a single customer do not ordinarily suffice, quote, even a single promotional presentation to an individual purchaser may be enough where the potential purchasers in the market are relatively limited in number. Well, that's interesting. So under the Lanham Act, the way, again, with your 4 prongs, let's go back to the 4 prongs. When you're talking about the speech itself, it's dissemination under here. Sufficiently disseminated to a relevant purchasing public to qualify as advertising or promotion within an industry. It's noting that typically, if you just had a sales rep, one person out there talking to a singular customer, that probably would not suffice. But a single promotional presentation to an individual purchaser may be enough, where the potential purchaser in the market are relatively limited in number. That's interesting. You know, what's problem with this, again, this stuff, the whole point, when they talk about like the Lanham Act and not understanding portions of the Lanham Act, well, because, you know, there's a lot of complicated law out there. And if you look at this, I mean, these are things that many of you probably have never seen before. For myself, you know, I've never gone down the rabbit hole of competitor protection as far as, you know, of false representation and going out again and trying to basically smear someone's name and bringing customers to you. And it's interesting in this setup, you have a very distinctive type of law, but the magistrate that's over it never changes. I mean, that's what blows my mind. They're supposed to know about everything that crosses their desk. And to me, that seems crazy. Of course, you have certain courts that have specific function. But my Lord, you can see why so many cases, they have problems. But here also, one letter to single customer constituted false advertising when relevant purchasing market was quite small. So off this, one letter to a single customer. Actionable statements do not need to be made in the form of classical advertising campaign and can include more formal types of promotion as long as they are sufficiently disseminated to relevant purchasing public. Now, this is interesting. You know what makes me wonder about it? So Lips was saying when they got their channel monetized, they were planning on taking the money that was there and using it as an advertising campaign, a classical advertising campaign, you know, in the classic sense on YouTube to go after Hales. And it's like, wow, you know, that's interesting on how, what laws they could break. But then again, you know, you have to get in front of somebody that recognizes it for what it is too. And also, social media posts are actionable under the Lanham Act. Now, that's interesting. Yeah. Thus, even individualized outreach to prospective customers can form the basis for actionable conduct under the Lanham Act. Case law noting individuals' letters sent to customers can give rise to Lanham Act false advertising claims. Also, here, statements by vendors representative in bid for contracts to Texas comptroller was actionable for false advertising under the Lanham Act. Now, 12 and 13, demonstrating the fact-intensive nature of the four-part test in determining whether speech constitutes, quote, commercial advertising or promotion under the Lanham Act as articulated by this case. So the magistrate judge erroneously attempts to draw a bright line by concluding YouTube broadcast or audio visual works or similar works, thus granting protection under Florida's anti-SLAPP statute. This is clearly erroneous. Quote, the use of technology in social media may be a means to present false and actionable statements under the Lanham Act. Actually, that if this is meant to state that it does not fall under the Lanham Act and it can't, that would make no sense to me anyway. Because again, think about the level of advertising that comes out of a place like YouTube or off of social media. To say that it doesn't, anyway. So for instance, using, quote, a domain name and Facebook page to make false advertising statements is actionable under the Lanham Act. Similarly, hashtagging a competitor's name or product in social media posts could, in certain circumstances, deceive customers and thus be actionable under the Lanham Act. So even hashtagging, boy, don't tell that to the antis. They'll be like, we don't hashtag, we mention. Oh my God. That's been the dumbest argument I've ever seen. These are mentions. Okay. All right. So in determining whether to dismiss under Rule 12b-6, a court accepts the factual allegations in the complaint as true and constitutes them in the light most favorable to the non-moving party. Here, the magistrate judge erred because the R&R dismissed fact-intensive claims without allowing further factual development. This approach does not align with a broader principle that factual disputes are generally inappropriate for solution on a motion to dismiss. The magistrate judge also erred by drawing inference based on facts pled in a light least favorable to the plaintiffs. This is the exact opposite of what the law mandates. The magistrate judge did this by stating, quote, what defendant Lee is alleged to have done would be better described as, quote, communicating information, expressing opinion, and reciting grievances regarding plaintiff. The magistrate judge draws inference against the plaintiffs in favor of defendant Lee. The case cited by magistrate judge to support the R&R is easily distinguishable from the case at bar. This is because in that case that he notes, the plaintiff failed to, quote, identify some medium or means through which the defendant disseminated information to a particular class of consumer. While the Lanham Act's commercial disparagement provision covers more than classic advertising campaigns, it is nonetheless aimed at specific forms of communication. Case law. To constitute advertising or promotion, commercial speech must at bare minimum target a class or category of purchasers or potential purchasers, not merely particular individuals. Again, case law with a quote here. Advertising is a form of promotion to anonymous recipients as distinguished from face-to-face communications. Another case here with a quote. A cause of action for commercial disparagement requires that the disparaging statement about another's product be published. Thus, to pass the pleading threshold in a Lanham Act, that would be 43A1B case, a plaintiff, at the very least, must identify some medium or means through which the defendant disseminated information to a particular class of consumers. And again, case law noting that identifying a false or misleading statement that was made, quote, commercial advertising or promotion, unquote, is a pleading requirement for product disparagement claim. The plaintiff's allegation here lacks this critical component. They do not implicate the use of any particular advertising or promotional medium. Here, number 4. This is the footnote here. The plaintiff tried to remedy this by adding new allegations for the first time during the appeal. This was not permitted. Quote, it is elementary that a plaintiff cannot constructively amend his complaint with an allegation made for the first time in the appellant brief. Well, thus, the argument has been waived. Now, again, case law with statement. It is a Hornbrook law that theories not raised squarely in the district court cannot be surfaced for the first time on appeal. And also, here's another similar collecting case. All right. Hey, we're moving along pretty decently. Now, the complaint in this case clearly identifies defendant Lisa Lee's YouTube as the medium or means through which she disseminated information to a particular class of customers. Thus, the determination of whether speech constitutes, quote, commercial advertising or promotion, unquote, under the Lanham Act involves factual questions that preclude dismissal at the motion to dismiss stage, particularly in the 11th Circuit. Therefore, the court should reject the above finding as clearly erroneous or misapplying controlling law. Now, objection 3. The magistrate judge erred in dismissing tortious interference claims against Lisa Lee and Bruce Manskin. Oh my God. I almost messed that up. I must said it backwards. My mind, for some reason, went karate. It was like against Bruce Lee and Lisa Manskin. I was like, no, wait a minute. That's not right. I almost messed that one up. The magistrate judge erred in concluding that the plaintiff's allegations of business relationships with social media subscribers, followers, and platform users failed to satisfy Florida's, quote, identifiable customer requirement for tortious interference claims. The magistrate judge erred in concluding plaintiff's second amended complaint does not identify any customers. It simply generically refers to customers. This is because the R&R applies an overly restrictive interpretation of controlling Florida law that conflates identifiable and individually identified by name and fails to account for modern digital platform business models where revenue is generated through defined classes of economically connected users. The magistrate judge committed legal error by requiring the plaintiff identify customers individually by name rather than economically defined classes. See, I thought this was a big question there. And yeah, it's insane. Hey, identify every single one of your customers by name. What? How? Imagine that. I mean, it's so crazy to note there. Instead of an economically defined class, thereby imposing a pleading standard inconsistent with the Florida Supreme Court precedent as applied by the 11th Circuit. This objection demonstrates that the complaint alleges sufficient facts to state plausible claims for tortious interference with business relationships under Florida law. Now, Florida law requires identifiable customers. I thought this stuff was really interesting. It really gets into the idea where how social media would work and how some of this would come together. And really how a lot of stuff is being left on the proverbial cutting room floor. So the elements of tortious interference under Florida law as applied in the 11th Circuit. To establish a claim of tortious interference with a present or prospective business relationship in Florida, plaintiff must show the existence of a business relationship that affords the plaintiff existing or prospective legal rights, the defendant's knowledge of a business relationship, the defendant's intentional and unjustified interference, and damage to the plaintiff. Again, the best way to imagine tortious interference, very simple way, maybe oversimplified, but check this out. Let's do this here. Give me 1 second. Look, this is going to be terrible, but we'll do it this way. You know, when we talk about that, let's give ourselves a pencil. Look, we'll give it a terrible line, right? We have party A and party B, right? So these folks, they have a business relationship, you know, a contract, whatever, right? It's provable business. Then, just like in any conversation, people use this for conversation, you have a C party, and this C party sees itself right into that, you know, therefore damaging this AB relationship here. And, you know, of course, you have to be able to prove damages. It's pretty cut and dry idea. But tortious interference claims cases are very difficult sometimes. I mean, they are way beyond sometimes. It's amazing. So Florida law requires 5 elements to establish a cause of action for tortious interference with contractual relationships. Yeah, I know, that was my Bob Ross moment. Exactly. We're gonna paint a pretty tortious interference claim. Oh, look, we're gonna surround it with beautiful fluffy clouds. Oh, do you see those fluffy clouds? Oh, Lord. So you need the existence of a contract, the plaintiff's knowledge of a contract, the defendant's intentional procurement of the contract's breach, absence of any justification or privilege, and damages resulting from the breach. The 11th Circuit has recognized that the plaintiff cannot establish a cause of action in a tortious interference case if the defendant merely provided truthful information to a third party. However, the critical issue in this case concerns the first element, whether the complaint adequately alleges the existence of business relationships that afford plaintiff existing or prospective legal rights. So B here. Florida law requires identifiable customers, non-individually named customers. Interesting, huh? The magistrate's analysis improperly requires individual identification of customer by name rather than identification, we'll get it right in a minute, of customer classes with sufficient economic and factual particularity. Under Florida law, tortious interference claim requires, quote, a business relationship evidenced by an actual and identifiable understanding or agreement, which in all probability would have been completed if not, I almost went Scooby-Doo on that. I was like, if not for those pesky kids. Completed if the defendant had not interfered. The Florida Supreme Court has held that, quote, to establish the tort of tortious interference with a business relationship, the plaintiff must prove a business relationship with identifiable customers. Now, the critical distinction in Florida law is between relationships with identifiable customers and impermissible claims of interference with a business's relationship to the community at large. This is because, quote, no cause of action exists for tortious interference with a business relationship to the community at large. However, the requirement that customers be identified does not mandate that each individual customer be identified by name in the complaint. See, this is a problem that came up when we were talking about Fed 1, because this was the same road that was being tracked. And we were talking about how insane that seems, you know, identify each customer by name. The term identifiable in Florida law denotes a particular understanding or agreement. Now, the focus is on whether the business relationship is sufficiently particularized to distinguish it from Jay. I know this guy's voice is fake Southern accent. It's nearly worse than mine. Oh, Lord. Oh, Lord, Lord. Wait. Is yours supposed to be a Southern accent? I have never thought that for a moment, Jay. I have never thought that guy is a Southerner. Never once. Oh, Lord. That's hilarious. But it, again, is sufficiently particularized to distinguish it from a generalized relationship with the public, not whether every individual customer can be named. So the magistrate's analysis conflates pleading standards with proof requirements. So the magistrate's conclusion that generic references to customers are insufficient improperly imports evidentiary standards in the motion to dismiss analysis. At the pleading stage, the complaint need not identify customers with the specificity required at trial. The element of tortious interference requires that, quote, the plaintiff must prove a business relationship with identifiable customers, but this proof requirement does not dictate the level of specificity required in the complaint to survive a motion to dismiss. The complaint here alleges multiple distinct categories of revenue-generating business relationships, each defined by the economic nature of the relationship and supported by quantifiable metrics. D. The complaint alleges multiple categories of identifiable business relationships. The YouTube Partner Program subscribers constitute identifiable customers. So the complaint alleges that plaintiffs participate in the YouTube Partner Program with over 730K subs who generate revenue through the program. The allegation identifies a specific economically driven class of customers, individuals who subscribe to plaintiff's YouTube channel and whose engagement generates revenue through the YouTube Partner Program. These subscribers are not, quote unquote, community at large, but rather a defined subset of YouTube users who have taken affirmative steps to establish ongoing relations with the plaintiff's content. That is indeed true. Again, you can't say that if subscribers generate my revenue, that if them leaving, they're just the community at large. That's not, if someone's driving them away, again, the definition there, if so, it feels like essentially the way that the magistrate words specific things, it feels like he's saying, hey, you got a business out there online. Well, anybody can do anything to it. It's kind of a frightening idea. So the magistrate judge accepted that the relationship with YouTube itself constitutes a sufficiently specific business relationship. However, YouTube Partner Program relationship is fundamentally dependent on the subscriber relationship. Without subscribers, there's no partner program revenue. These subscribers are not merely incidental to the business relationship, they're economic foundation of it. This distinguishes the present case from the case cases finding insufficient specificity where plaintiffs allege only generalized loss of business. Here, a case cited by the magistrate, by the way, the court dismissed without prejudice, they can, with leave to amend, a tortious interference claim where the plaintiff failed to identify any specific customers or business relationships beyond a generalized loss of business. Here, by contrast, the complaint identifies a specific revenue-generating mechanism, the YouTube Partner Program, a quantified subscriber base, 730K plus, and the economic nature of the relationship, revenue generated through subscriber engagement. So paying subscribers constitute identifiable consumers or customers. The complaint alleges that subscribers pay monthly fees to plaintiff for premium access to social media content. Those paying subscribers constitute an even more clearly identifiable class of customers through general YouTube subscribers, or rather than general, yes. So it becomes even more identifiable. You know, when you have people that, by the way, if you enjoy this content and you too would like to become a paying subscriber, you would like to pick up membership here, definitely. Or if you would like to help out others become that, well, feel free. That would be amazing. Actually, a few of you have definitely been doing that throughout this, and thank you. Appreciate you. Individuals who pay recurring monthly fees for access to content have entered into an ongoing business relationships, quote, evidenced by an actual and identifiable understanding or agreement. The economic relationship between plaintiffs and paying subscribers is direct and quantifiable. Each paying subscriber has made an affirmative decision to enter into a financial relationship with plaintiffs, distinguishing them from passive viewers or the general public. This is precisely the type of, quote, actual and identifiable understanding or agreement, unquote, that Florida law protects from tortious interference. Auction purchasers through Whatnot constitute identifiable customers. The complaint alleges that plaintiff sells items. Yeah, indeed. You know, the plaintiff, they also sell on Whatnot, you know, the place that these people wrote and tried to destroy the relationship with. And I believe did damage the agreement with as well. So the complaint alleges that plaintiffs sell items via Whatnot online auctions. Individuals who purchase items through these auctions are customers in the most traditional sense. They engage in specific transactions to purchase goods. The magistrate accepted that the relationship with Whatnot Inc. itself is sufficiently specific. However, the customers who purchase items through the Whatnot platform are the ultimate source of revenue for that relationship. Indeed. Indeed. These auction purchasers are readily identifiable as a class. Individuals who have participated in plaintiffs' Whatnot auctions and completed purchases. They are not the community at large, but rather a defined group of individuals who have entered into specific transactional relationships with the plaintiff. So revenue generating followers and users constitute identifiable customers. The complaint alleges that plaintiff has Facebook business page with over 327,000 followers, operates as a TikTok creator, generating revenue through sponsorship tips and affiliate links. These followers and users constitute identifiable customer classes defined by revenue generating relationship with plaintiff. Followers who generate advertising revenue, users who provide tips, and individuals who make purchases through affiliate links are not passive members of the public. They are economically connected participants in plaintiff's business model who have taken affirmative steps to engage with plaintiff's content in ways that generate revenue. This complaint's identification of specific revenue mechanisms, advertising tips, sponsorships, or affiliate links, and the quantification of follower base, 327K on Facebook, provides sufficient particularity to distinguish these relationships from relationships with the community at large. Indeed. Indeed. Let's see, with the whole thing in regards to the customer relationship, doesn't that mean BBB? And some of them have a relationship with What the Hales because they are members to get things from Whatnot as well. Yeah, actually, you know, what's funny is some of them have memberships to some of our channels. So doesn't that mean that they would be our customers too? You know, actually, what's even crazier, if you went forward with this, what I would think you would get into is that defendant Lee was at one time a consumer or a customer with What the Hales. In fact, they were a moderator, but they thought they would get more. They thought that they would. They thought that because he shouted them out or whatever, they become as big as he has. And when they didn't, they created a business that was intended to burn it all down. You know. Oh, hey, hollow bongs. So 70 pages of coping and seething. Another ale. You know, thank you for the $5 on that. Appreciate it. Again, what I think that you could do with this is I think that the whole purpose in that is if you do not change the reports and recommendations, what you end up doing is getting it added as a without prejudice. So if they can manage to get this type changed over, then that allows them to come back at a later date and they can either amend this complaint or amend period. You know, we'll see. It's one heck of a file like that. I actually think the part about customers, the part about identifiable customers here, 100%. That with the magistrate, he does not have, it's like some old school thinking about what constitutes customers. I also like the fact that this stuff goes two ways. So, you know, if it is not interference, then, well, if anybody ever does build up, they have to worry about the fact that the same thing could be applied to them. Same thing could happen to them as well. So let's see. The magistrate's analysis is inconsistent with controlling authority. The cases cited by the magistrate are distinguishable. The magistrate relied on this case here and this case here. You can see the two. There's actually two here if you're curious about them, you know. For the proposition that generic references to customers are insufficient. However, as discussed, these cases are readily distinguishable from present allegations. In the first here, the court found insufficient specificity where the plaintiff alleged only that the defendant interfered with sales to quote unquote various customers without any further identification or description of those customers. The court held that quote, the cause of action cannot be established by proof that the defendant interfered with the relationship between the plaintiff and the public at large. An additional distinguishing factor is that the court in this only dismissed the case without prejudice, allowing a leave to amend the correct and add more detail than various customers. Here, by contrast, the complaint does not allege merely that defendant Lee interfered with sales to various customers. Rather, the complaint identifies multiple specific categories of business relationships, each defined by economic nature of the relationship by support and supported by quantifiable metrics. 730K plus YouTube subscribers in the partner program, subscribers paying monthly fees, 327,000 Facebook followers generating advertising revenue, TikTok, and whatnot. So, similarly, in the second case noted, the court found insufficient specificity where plaintiff failed to specifically identify in the complaint the customers or our clients that are the subject of the defendant's alleged interference. However, that case does not hold that plaintiffs must identify customers by individual name. Rather, it requires the complaint, quote unquote, specifically identify the customers or clients, a requirement that can be satisfied by identifying defined classes of customers with sufficient economic and factual particularity. Now, the complaint satisfies the requirements of, again, you'll see how the requirements come together here. So the Florida Supreme Court decision in these cases establishes a controlling standard. Now, these cases hold that tortious interference claims require, quote, a business relationship evidenced by an actual and identifiable understanding or agreement, and a business relationship with identifiable customers. The complaint here alleges multiple business relationships evidenced by actual and identifiable understanding or agreement. The YouTube Partner Program relationship involves an agreement under which plaintiffs receive revenue based on subscriber engagement. The paying subscriber relationship involves agreements under which subscribers pay monthly fees for premium content access. The Whatnot auction relationships involve agreements under which purchasers buy items through the platform. Each of these constitutes, quote, and actual and identifiable understanding or agreement within all probability would have been completed if the defendant had not interfered. Now, the customers in each category are identifiable in the sense required by First in Transportation. They are defined classes of individuals who have entered into specific economic relationships with plaintiff, not the undifferentiated public. So G, the magistrate analysis fails to account for modern digital business models. I think this, again, is a huge problem. 21st, and not just in, I'm talking about in cases, period. 21st century digital platform business models require functional application of identifiability requirement. The identifiable customer requirement was developed in context of traditional brick and mortar businesses with relatively small numbers of customers. Applying this requirement to modern digital platform businesses with hundreds of thousands of subscribers and followers requires an approach that focuses on whether the alleged business relationships are sufficiently particularized to distinguish them from relationships with the community at large. This is because a social media influencer's business model is fundamentally different from a traditional retail business. Revenue is generated not through individual transactions with a small number of customers, but through aggregate engagement by large numbers of subscribers, followers, and users. Requiring individual information by name of each subscriber or follower would effectively immunize tortious interference with digital platform business, as such business necessarily involve large, diffuse customer bases. See, that would be a problem there. Hey, if you got to be able to name every single customer that's out there, then essentially every business, every one of them is going to have a problem. Thus, the proper inquiry is whether the complaint identifies customer classes with sufficient economic and factual particularity to distinguish them from, quote, the community at large. Here, the complaint does so by identifying, one, the specific platforms through which relationships are established, YouTube, Facebook, TikTok, or whatnot. Two, the specific revenue mechanisms, that would be a partner program, monthly fees, advertising, tips, sponsorships, affiliate links, auction, sales. Three, quantified metrics. Again, you see the size, 1 million freaking people across multiple platforms. And four, the substantial investment in acquiring and maintaining these relationships. Now, the economic value and quantifiability, there we go, of relationships support identifiability. The complaint alleges that plaintiffs, quote, expended substantial time, money, and resources acquiring subscribers and maintaining relationships with them. See, that's another thing. If subscribers are just the community at large, then why am I hunting, them down and really spending substantial amounts of, let's say diminishing resources, because time is a diminishing resource as well as money and other sources. Why would I be spending those if we were just talking about the community at large? There has to be something particularized in that makes it worthwhile where you would want to spend, to obtain. So this allegation provides actual factual context distinguishing these subscriber relationships from generic relationships with the community at large. The cause of action for tortious interference with business relationships, quote, recognizes that economic relationships are entitled to freedom from unreasonable interference. The economic value and quantifiability. Yeah, cynic. I think if they downgrade to dismissal without prejudice, I can't speak to what they will do. Now, this is just my idea. But here's the thing. I believe when they first put this together, Jeremy Hales was arguing, he wants everything to stop. And he was like, all of these people have to pay now. They have to right now. Now, looking at the massive undertaking that Fed2 is. Fed2, like I said, Fed2 is another $500,000 easily. 10 people that would be in a case if you move forward with it. I mean, you're talking about, potentially a quarter of $1 million to $1 million case. I mean, it's a crazy amount. I can only imagine, especially considering every one of these people. You got to think, Bolitho has also allowed them to run ramshot over the entire case. He's allowed them to do whatever, and that's run up the costs. So you can imagine when you get to specific portions of the case, if he's not going to step on the brake and be like, do this or else, how expensive that would be. I would think, I said, people like Elisa Lee, you could get right now. I mean, she's looking at some real problems just through the bankruptcy mess alone. And he has a very good claim against her for defamation, accusing him of essay. Like, you don't need all of this right now. Now, again, I'm not saying that pro or con, like moving forward with this. Again, that's not my call. I don't know. That's up to that's with lawyers or whomever. But I think that like Bruce has already gotten himself into some hot water. Let's just say, he definitely caused himself some problems, and potentially, again, if they regroup, they look at claims and they decide what to go over and who, you want every one of these people to pay at the same time. Hales is never going to recoup this amount. I mean, these people don't have that he may be able to lord over their lives essentially with, with an attempt to recoup. But if you look at cases and how you recover money, or if you don't recover money, it becomes a mess there, It's all crazy. But anyway, continuing here. The economic value, quantifiability of, again, this, we've got the 730 monthly fees, etc., and auctions. They demonstrate that these are protected business relationships, not merely relationships with undifferentiated public. Yes. When you look at the amount of revenue, if that just comes from the public, man, they just generalize the masses, the mob, then wow, The complaint seeks $1.835 million in damages for tortious interference. This is a substantial damages claim reflecting the economic value of business relationships at issue and further distinguishes them from generalized relationships with the community at large. So the magistrate's acceptance of platform provider relationships undermines the conclusion regarding end-user relationships. So platform relationships are derivative of end-user relationships. The magistrate accepted that the relationships with YouTube and whatnot constitute sufficiently specific business relationships. However, this acceptance is logically inconsistent with the conclusion that subscribers and consumer relationships are insufficiently specific. The YouTube Partner Program relationship exists solely because of plaintiff's subscriber base. YouTube pays revenue to plaintiffs based on subscriber engagement with plaintiffs' content. Without the subscribers, there's no partner program. You don't have it. I mean, and that makes sense. Similarly, Whatnot relationship exists to facilitate sales to customers who purchase items through the platform. The platform provider relationship, a derivative of and dependent on the end user relationships, you know? Oh yeah, that's what I'm saying, Cynic. What I personally, my opinion is you take lips and chips with the SA claim, with the agreement claims and more. You hit them with it, and then after that's there, then you go after 2L. That's the way I do it. I pick them off, like, you know, I pick them off in pieces, portions there. The platform provider relationships are derivative of and dependent upon the end user relationship. Inasmuch as interference with YouTube relationship is actionable, then interference with the subscriber relationship that constitutes the economic foundation of the YouTuber relationship must also be actionable. The magistrate's analysis artificially severs the platform provider relationship from the end user relationship, even though they are economically inseparable. Yeah, I don't see how you do that and pretend, you know, one without the other. Interference with, 1 second here. Interference with platform relationships necessarily affects end-user relationships. The multi-layered nature of 21st century platform-based businesses means that interference with platform provider relationship necessarily affects the end-user relationship that platforms facilitate. If a defendant Lee conduct interfered with plaintiff's YouTube relationship, that interference would necessarily impact plaintiff's ability to generate revenue from the 730K subscribers. Similarly, Manskin's interference with the Whatnot relationship would necessarily impact plaintiff's ability to sell items to auction purchasers. The magistrate's acceptance that platform provider relationships are sufficiently specific, but end user relationships are not, creates an artificial distinction that fails to account for the economic reality of platform based business. That 100%. You can't. I don't see how you can sever those. I don't see how. So partial insufficiency does not warrant total dismissal. Even if the court were to conclude that generic references to customers and other companies are insufficiently specific, that does not warrant dismissal of the entire tortious interference claim. The complaint alleges multiple distinct categories of business relationships, several of which are alleged with sufficient specificity. At minimum, the complaint sufficiently alleges business relationships with YouTube through the partner program, Whatnot, auction sales, subscribers paying monthly fees for premium content, YouTube subscribers generating partner program revenue, and followers and users generating revenue through advertising, tips, sponsorships, and affiliate links. Each of these categories is identified with specific economic and factual particularity to distinguish it from relationships with the community at large. If the court concludes that some categories are sufficiently specific while others are not, the appropriate remedy is to allow the claim to proceed based on the sufficient specific allegations, not to dismiss the entire count. The magistrate erred in concluding that the complaint fails to allege business relationships with identifiable customers, The complaint alleges multiple distinct categories of business relationships, each defined by specific economic connections and supported by quantifiable metrics. These allegations satisfy Florida's requirement that tortious interference claims involve relationships with identifiable customers rather than relationships with the community at large. By the way, why they front load all the allegations about Jeremy Hales doing this for YouTube content, because all that shit wouldn't fly if you ever get to a jury. They hoped to overwhelm an audience of one with all these claims, because ultimately when you're playing to a jury, I think some of the things that these people have done, they know will be bad. So they hope to God they can influence the judge, magistrate before we get to that point. Otherwise, they have a problem. So they do anything. And that's been their go-to. That's true, Polar Spark. It's very true. The magistrate's analysis, again, improperly complaints identifiable with individually identified by name and fails to account for the economic reality of the modern digital platform business models. The complaint alleges that plaintiffs have business relationships with 730K YouTube subscribers, generating partner program revenue, subscribers paying monthly fees, etc., etc. You've heard all of that before. So I'm going to skip to here. Moreover, the magistrate's acceptance that provider platform relationships, YouTube and whatnot, are sufficiently specific is logically inconsistent with the conclusion that end user relationships are insufficiently specific, given that platform relationships are derivative of and dependent upon end user relationships. Finally, magistrate erred in concluding that plaintiffs failed to plausibly allege damages. The second amended complaint specifically alleges plaintiffs suffered injury and harm to reputation and has incurred costs associated with its extensive effort to mitigate against such injury and harm. Additionally, the complaint alleges that plaintiff lost revenue streams that otherwise would remain with them absent defendant's interference with plaintiff's valid business relationships. So plaintiff objects to the magistrate judge's report and recommendations regarding dismissal with prejudice of count 5, the tortious interference with business relationship claim against Bruce Madskin. So plaintiff respectfully objects to magistrate judge's report and recommendations recommending dismissal with prejudice of count 5, tortious interference against, again, Bruce. Magistrate applied an improperly heightened pleading standard inconsistent with Federal Rules of Civil Procedure 8A and the plausibility standard articulated in and here, and made factual determinations inappropriate at the motion to dismiss stage. When the second amended complaint's allegations are accepted as true and all reasonable inferences are drawn in plaintiff's favor as required, the complaint plausibly states a claim for tortious interference under Florida law. The complaint adequately alleges the existence of business relationships. The magistrate applied an improperly heightened pleading standard. As shown, again, it talks about all of the business elements that we've just seen. So I'm moving through this. This is something we just read, essentially. Okay. As far as Florida law does not require naming individual customers at the pleading stage too. We've heard about how this works, how the pleading stage, how that's satisfied. So through this, again, we have essentially, it's repetition because of the way the items come up. So those 2 pages are essentially repetition. Again, you read them all if you want to. Like I said, those two we'll jump over. The complaint plausibly alleges intentional and unjustified interference. The magistrate judge improperly required proof of direct contact beyond what is alleged. The magistrate's most significant error lies in concluding that the complaint fails to plausibly allege intentional and unjustified interference. The magistrate found that plaintiffs have not plausibly alleged that defendant Manskin contacted YouTube representatives or otherwise did anything to interfere with a business relationship that plaintiff allegedly had with YouTube. However, the finding simply ignores the specific allegations regarding Manskin's contact with Whatnot. The second amended complaint alleges that on February 17th, 2025, Manskin contacts Whatnot, a company which has a business relationship with Hales, via email, makes false statements to Whatnot, copying a third party as well, as part of malicious conspiracy to harm Hales, to damage his business reputation and interfere with plaintiff's relationship with Whatnot Inc. The complaint further alleges that Manskin stated in the email that plaintiff was dragging Whatnot in a client scam of contrived litigation to create YouTube content for your client's storylines, and that plaintiff committed perjury and was falsely using Whatnot to support fake lawsuits. These allegations plainly describe direct contact between Manskin and a representative of Whatnot, one of plaintiff's identified business partners, in which Manskin made alleged false and disparaging statements about plaintiff's business practices, including YouTube and litigation conduct. This is precisely the type of conduct that constitutes, yes, I agree. How is this not him going? He directly contacts, lies about stuff. I mean, again, we've seen the emails. They are nasty, malicious, garbage. It's amazing to look at those and be like, well, actually, the magistrate misapplies duty-free Americans. The magistrate relies on duty-free Americans. Again, that's a case there is misplaced. This is because in duty-free Americans, the 11th Circuit affirmed dismissal where there's no allegation that the defendant conveyed the information in question to the entity with which the plaintiff had a business relationship. Here, by contrast, the plaintiff specifically alleges that defendant Manskin did convey information, false and disparaging information, directly to Whatnot via email. The complaint alleges that the email was sent to a Whatnot representative and copied to a third party, demonstrating that Manskin intentionally communicated with plaintiff's business partner for the purpose of damaging that relationship. This utterly here's a weird question for you. This is just random, folks. But you know how they all keep saying that anybody who talks about this case and doesn't agree with them, that we're in business relationships with Hales. You know, they keep saying that, right? So if they believe that, then all of their emails and all of these insane threats and other bullshit, wouldn't that be interference with a business relationship? Does that mean they don't actually believe that exists? Kind of, Well, they just don't care. You know, because it's funny, they keep saying it over and over again, right? That it exists. Although to have a business relationship like that, you would have to have what's that thing? Oh yeah, money, you know, money, payment. But such a stupid thing, you know. Hey, Caroline, thanks for the. Let's see. Thank you for taking on the Trading Post thing as well, so Willis can continue doing fun things. Yeah, he doesn't. Here's the thing. Travis doesn't really want to get into, so just discussing that for a minute. Travis doesn't want to be part of drama. He doesn't like it. I thrive in this mess, you know. I have fun with it. I don't give a shit. Like, people aren't going to threaten me and ruin something, but they can. With people like Travis, they hurt his relationship with the community at large. They do. They harm it quite a bit. And for myself, they don't hurt anything. So I understand when people are, you know, talking about this, I'm like, hey, you know, I'll cover whatever. Let them point their angry little thrashing about and stuff. The only problem is people like for Travis, for example, these people, they don't stop targeting him, you know. That's the ugly part. But anyway. So the complaint alleges additional conduct constituting interference. Beyond the direct email contact with Whatnot, the complaint alleges a pattern of conduct by Manskin designed to interfere with plaintiff's business relationship. The complaint alleges that defendant Manskin publicly states false information about plaintiff, including that plaintiff is a public stalker of private victims, has fabricated storylines using innocent, powerless people lives to sell as entertainment for profit. That complaint further alleges that Manskin appeared on YouTube channels operated by other defendants and made additional false statements about plaintiff. While the magistrate judge found that there are allegations that defendant Manskin posted conduct about plaintiff Hales on YouTube, the magistrate judge dismissed these allegations as insufficient because plaintiffs are not plausibly alleged that defendant Manskin contacted YouTube representatives. Holy shit. You want an email to YouTube, guys? They exist. Oh, he definitely did. He made it very clear. He has contacted YouTube multiple times. He was told by YouTube legal, hey, won't you leave us alone? I mean, it's kind of crazy stuff. But this analysis improperly conflates two distinct theories of interference. Manskin's public statements on YouTube and other platforms, combined with his direct contact with Whatnot, possibly allege a coordinated campaign to damage plaintiff's business relationships and reputation. The complaint and adequately alleges causation and actual interference. The magistrate improperly required allegations of formal termination. The plaintiff erred in concluding that the complaint fails to plausibly allege causation because there are no allegations that Whatnot terminated his contract with plaintiff, denied plaintiff access to the Whatnot platform, or otherwise altered the plaintiff's business relationship with Whatnot as a result of Manskin's conduct. This imposes a requirement that Florida law does not mandate. Florida law does not require that a business relationship be completely terminated to establish tortious interference. Rather, the plaintiff must show damage to the plaintiff as a result of the interference. Damage to the business relationship can occur without formal termination, including through harm to plaintiff's reputation with the business partner, erosion of trust, economic losses resulting from the defendant's interference. This case here does not require pleading termination. The magistrate's citation of this case does not support the requirement that plaintiff must allege termination of a business relationship. That stands for the proposition that the lack of causal relationship between the alleged interference and the failure of the agreement precludes recovery as a matter of law. Here, the complaint alleges a causal relationship between Manskin's conduct and damage to the plaintiff's business relationships. The complaint alleges that Manskin's email to Whatnot was sent, quote unquote, to damage Hale's business reputation and interfere with Hale's relationship with Whatnot Inc. The complaint further alleges that, quote, Hales is damaged by Manskin's unlawful conduct by losing revenue streams that would otherwise remain with Hales absent Manskin's interference with Hale's valid business relationships. These allegations establish the requisite causal connection between the interference and the damages. Now, the nature of plaintiff's business supports finding of interference. The nature of plaintiff's business, social media content creation dependent on platform relationships, supports a finding that defendant Manskin's conduct constitutes actionable interference. Plaintiff's business model depends on maintaining positive relationships with platforms like YouTube and Whatnot. When an attorney representing adverse parties in related litigation contacts one of these business partners and makes false statements about plaintiff's litigation conduct, characterizing as a scam and accusing the plaintiff of perjury, this conduct is reasonably calculated to damage the business relationship, even if it does not result in immediate termination. The complaint adequately alleges damages. The magistrate applied an improperly heightened pleading standard for damages. The magistrate judge erred in concluding that plaintiffs have failed to plausibly allege the fourth element of a tortious interference claim because the allegations of the second amended complaint fail to plausibly connect defendant Manskin's supposed tortious interference to the breach of any contract or the loss of any business relationship. This finding imposes a specificity requirement for pleading damages that exceeds what Rule 8 and Rule 9 require. This is because the Federal Rule of Civil Procedure 8A2 requires only, quote, a short and plain statement of the claim showing that the pleader is entitled to relief. Rule 9B, which requires particularity for fraud claims, expressly provides that, quote, malice intent, knowledge, and other conditions of a person's mind may be alleged generally and does not impose heightened pleading requirements for damages. The complaint alleges that plaintiff seeks $1.229 million in damages for Manskin's tortious interference, and that, quote, Hales is damaged by Manskin's unlawful conduct by losing revenue streams that would otherwise would remain with Hales absent Manskin's interference with Hales' valid business relationships. Damages, they need not be proven at the pleading stage. Now, while damages are, quote, an essential element of the tortious interference claim, the plaintiff need not provide the precise amount or mechanism of damages at the pleading stage. A plaintiff must only allege that the injury caused damages to state tortious interference cause of action, and need not specify what the actual damages were at this stage of litigation. So with case here, first, defendant does not argue that plaintiff has failed to plead any of the prima facie elements of a claim for tortious interference. Rather, defendant's causation arguments against the tortious interference claim essentially boil down to a claim that the plaintiff will not be able to prove this case. However, the court's analysis at the pleading stage of the case is not centered on whether plaintiff will be able to prove its case, but on whether the amended complaint contains sufficient factual matter to state a claim for relief that is plausible on its face. Again, you notice they're saying, well, you're asking for too much. That's essentially, you are asking for way too much. At this stage, we're just at the dismissal stage. You're asking for way too much proof. We're at the pleading stage, not the proof stage, as stated in other cases. And also another case, observing the defendant's causation challenge in its motion to dismiss was inappropriate. Here also, plaintiff does not need to prove causation at the pleading stage. While it may fail at summary judgment or at trial, it must at this stage only allege a short and plain statement of the claim showing that the pleader is entitled to relief. The complaint must merely allege damages sufficient to provide notice to the defendant and demonstrate that the plaintiff has suffered harm. Here, the complaint alleges a specific dollar amount, $1.229 million, and identifies the general nature of the damages, lost revenue streams, and damages to business relationships. This satisfies Rule 8 notice pleading requirement. The magistrate's requirement that a complaint, quote, allege the value of such breached contract or lost business relationship that resulted from defendant Manskin's conduct improperly conflates pleading with proof. At the motion to dismiss stage, the plaintiff need not provide detailed calculations or itemized damages. Such specificity is appropriately reserved for discovery and summary judgment proceedings. Now, the complaint alleges sufficient connection between conduct and damages. So the complaint adequately alleges the connection between Manskin's conduct and plaintiff's damages. The complaint alleges that Manskin contacted Whatnot, made false statements designed to damage business relationships and interfere with business relationships, or business reputation rather, and interfere with the relationship. The complaint further alleges that Manskin engaged in a broader campaign of making false public statements about plaintiff's business practices. The complaint alleges that as a result of this conduct, plaintiffs suffered lost revenue streams and damage to reputation and business relationships. Drawing all reasonable inference in a plaintiff's favor, and these allegations plausibly establish that Manskin's interference caused economic harm to plaintiffs. The complaint need not specify the precise dollar amount attributable to each act of interference or provide a detailed accounting of lost revenue at the pleading stage. Now, dismissal with prejudice is inappropriate. Plaintiff should be afforded opportunity to amend. Even if the court were to find deficiencies in the complaint's allegations regarding counts 4 and 5, dismissal with prejudice is inappropriate. The U.S. Supreme Court in Foman versus Davis emphasized that leave to amend should be granted unless there is a justification to deny it, such as undue delay, bad faith, repeated failure to cure deficiencies, undue prejudice to the opposing party, or futility of the amendment. The court held that outright refusal to grant leave to amend without justification constitutes an abuse of discretion and is inconsistent with the spirit of federal law. The magistrate recommended dismissal with prejudice on the grounds that plaintiff already had been given an opportunity to correct the pleadings. However, the prior amendment was filed in response to a motion for a more definitive statement filed by defendant Hale, not in response to any motion challenging the sufficiency of the tortious interference allegations in counts 4 or 5. That's true. That's absolutely true. You had an amendment because of Hale alone. That means that plaintiffs were not given specific notice of the alleged deficiencies in the tortious interference claims and were not afforded a meaningful opportunity to cure those deficiencies. Now, the prior amendment did not address tortious interference issues. The procedural history demonstrates that plaintiff's prior amendment did not address the specific pleading issues identified by the magistrate regarding the tortious interference claim. Defendant Hale filed a motion for a more definitive statement, which led to the court ordering plaintiff to file an amended complaint. The court instructed plaintiff's counsel to, quote, familiarize himself with the 11th Circuit's proceeding on shotgun pleadings before filing the amended complaint. Now, the procedural history shows that the prior amendment was focused on addressing, quote-unquote, shotgun pleading concerns and providing a more definitive statement, not on addressing the specific elements of a tortious interference claim. Plaintiff should be afforded at least one more opportunity to amend the complaint to address specific deficiencies identified by the magistrate regarding tortious interference allegations. Now, the interests of justice favor allowing amendment. The decision whether to grant leave to amend is committed to sound discretion of the trial court. Notes, again, case law. Rule 15A severely restricts the district court's freedom directly to leave to amend directing that leave to amend, okay, right there, shall be freely given when justice so requires. This policy of Rule 15A and liberally permitting amendments to facilitate determination of claim on merits circumscribes the exercise of the district court's discretion. Thus, unless a substantial reason exists to deny leave of amendment, or to amend rather, the discretion of the district court is not broad enough to permit denial. Hey, give me 1 minute. I'm going to mute for 1 minute. I got to go upstairs and grab a water. I just ran out. I didn't bring an extra with me. Mods, if you would tell people, if they're like, what the heck? I will be back within less than a minute. So All right, I'm back. Sorry about that. I get a water. I ran out. There's a Coke over here, but I'm trying not to drink them. You know, I only brought one water over here. A lot more hours than water, let's just say. All right, let's continue. So here, there's no indication that plaintiffs have abused the privilege of amendment. Plaintiff filed one amended complaint in response to a motion for more definitive statement, and that amendment was not directed to curing deficiencies for a tortious interference claim. If the court finds that the complaint fails to adequately allege specific elements of the tortious interference claim, plaintiffs should be permitted to file a third amended complaint addressing those deficiencies. For example, if the court finds that the complaint should detail more or should provide more detail regarding the mechanism by which Manskin's contact with whatnot damaged the business relationship, or should allege more specifically the nature and amount, plaintiffs can readily provide such additional detail. The magistrate failed to draw all reasonable inferences in plaintiff's favor. The magistrate made impermissible factual determinations. Throughout the analysis, the magistrate judge made factual determinations that are inappropriate at this motion to dismiss stage. For example, the magistrate found that Manskin's, quote, contact with whatnot representative during an email exchange regarding discovery in one of the other cases plaintiff Hales has filed did not actually interfere with plaintiff's business relationship with whatnot. This finding improperly weighs the evidence and makes credibility determinations. I think that's correct, to be honest. At this motion to dismiss stage, the court must accept as true the allegation the defendant Manskin email was sent to damage Hale's business relationship and to interfere with Hale's relationship with Whatnot Inc. The court must also accept as true the allegation that the email contained false statements, characterizing plaintiff's litigation as a scam and accusing plaintiff of perjury. Drawing all reasonable inferences in plaintiff's favor, it is plausible that an email from an attorney representing adverse parties sent to a business partner containing false accusations of fraud and perjury would damage the business relationship and cause economic harm. Whether Manskin's conduct actually caused such harm is a question of fact that resolved through discovery and at trial, not on a motion to dismiss. Indeed. I actually believe out of all arguments that it's insane to look at that. But this is the way the judge feels like they've got blinders on as far as that, because the judge, it's like, well, you sued him essentially because he's the lawyer for the other party. And it's like, no, this guy held court outside of court before anything actually went on. And he did all kinds of crazy stuff. I mean, you should also have the letters to YouTube and everything else in here as well, I believe. But the context, defendant Manskin's conduct supports plausibility. The complaint alleges that Manskin is an attorney who represented defendants Preston and Cook in related litigation against plaintiff. The complaint further alleges that Manskin contacted plaintiff's business partner, Whatnot, and made false statements about plaintiff's litigation conduct and related litigation. This God, you see how it just rolls back? It's like, blah, blah. It sometimes doesn't want to roll down. The context is significant because it demonstrates that Manskin, as an attorney, used his position to access to information about the litigation to contact plaintiff's business partner and make disparaging statements about plaintiff, drawing all reasonable inference in plaintiff's favor. This conduct plausibly constitutes intentional and unjustified interference with plaintiff's business relationship. An attorney's duty to zealously represent his clients does not extend to contacting the opposing business partner to make false and disparaging statements about the opposing party's litigation conduct. Indeed, to say that's just, in the course of being attorney is a bunch of BS. I mean, honestly. For the foregoing reasons, plaintiff respectfully requests that the court sustain these objections, request the magistrate report and recommendation as to counts 4 and 5, and deny Manskin's motion to dismiss tortious interference claim. Alternatively, if the court finds any deficiencies in the complaint allegation, plaintiff respectfully requests leave to file a third amended complaint to address those specific deficiencies. At a minimum, any dismissal should be without prejudice to allow plaintiff an opportunity to cure any pleading defects. The second amended complaint, when its allegations are accepted as true and all reasonable inferences are drawn in plaintiff's favor, plausibly state a claim for tortious interference with business relationships under Florida law. The complaint identifies specific business relationships. YouTube, whatnot, alleges Manskin had knowledge of those, alleges intentional interference through direct contact with whatnot, public disparagement, and alleges resulting damage. This is sufficient to survive a motion to dismiss under Rule 12b-6. Quote, therefore, the court should reject the report and recommendation and deny the motion to dismiss count 4 and 5. The complaint alleges sufficient facts to state plausible claims for tortious interference and with business relations under Florida law. I don't know why I said quote unquote. Objection 4. The magistrate judge erred in dismissing all civil conspiracy claims. The magistrate judge erroneously dismissed all civil conspiracy claims based solely on the conclusion that the underlying tort claim failed. As demonstrated above, underlying tort claims were inadequately pled and should not have been dismissed. Since the underlying claim should survive, the civil conspiracy claim predicated on them should likewise survive. Moreover, the magistrate judge erred in concluding the second amended complaint contains only conclusory allegations of an agreement without any factual basis to make the allegations plausible. To the contrary, the complaint contains specific factual allegations demonstrating an agreement amongst the defendants, including that they appeared together on each other's YouTube channels, communicated with each other about their common goal to take down plaintiffs, and referred to themselves as the anti-what-the-hales media ecosystem. Therefore, the court should reject the report and recommendation and deny the motion to dismiss all civil conspiracy claims. The complaint alleges sufficient facts to state plausible claims for civil conspiracy under Florida law. Now, this I thought was good too. The magistrate judge erred in characterizing the complaint as a shotgun pleading and recommending dismissal with prejudice. He said borders on. That's the crazy, like, you can't border on something. It either is or it isn't. So the magistrate judge improperly characterized plaintiff's second amended complaint as a shotgun pleading that borders on such a pleading. The 11th Circuit defines a shotgun pleading as one in which it is virtually impossible to know which allegations of fact are intended to support which claim for relief. However, plaintiff's complaint clearly delineates which allegations support which claims. This is because it is evident by the magistrate judge's own chart drawn up on page 4 in the R&R itself, in which the judge lists each defendant and corresponding legal claims and counts, including listing legal claims against defendant Lee as FDUPTA, Lanham, tortious interference, civil conspiracy. Indeed, if he can lay it out with a chart, then it's not a shotgun pleading. Holy moly. Even if the court finds that the second amended complaint is a shotgun pleading, dismissal with prejudice is an extreme sanction, not warranted here, misapplies controlling law. The magistrate judge's recommendation of dismissal with prejudice contradicts the 11th Circuit's guidance that plaintiffs should be given an opportunity to remedy any perceived pleading deficiencies through amendment. When faced with shotgun pleading, the proper remedy is not dismissal with prejudice, but rather to require the plaintiff to file a more definitive statement. The 11th Circuit has held that a defendant faced with a complaint such as Anderson's not expected to frame a responsive pleading. Rather, the defendant is expected to move the court pursuant to Rule 12E to require that the plaintiff file a more definitive statement. Here, only one defendant previously moved for a more definitive statement, which led to filing for a first amended complaint. No defendant moved under Rule 12E regarding the second amended complaint. Now, the attorney judge erred in recommending attorney fees to defendant Hale under Florida's anti-SLAPP. So the magistrate judge erroneously recommended awarding attorney fees to Hale under Florida's anti-SLAPP. This is flawed for two reasons. First, as demonstrated supra, plaintiff's sole count 12 against Hale for civil conspiracy is not without merit as required by anti-SLAPP statute. Count 12 states Hale and all defendants agree to intentionally participate in a civil conspiracy among themselves and with other individuals, the purpose of which was to commit violations. Number one, violations of the Florida Deceptive and Unfair Trade Practices Act. 2, against the Lanham Act. 3, tortious interference. The second amended complaint states a plausible civil conspiracy claim against Hale. Plaintiffs adequately alleged actionable underlying tort. Under Florida law, a civil conspiracy claim requires 1, an agreement between 2 or more parties, 2, to do an unlawful act or a lawful act by unlawful means, 3, the execution of some overt act in pursuance of a conspiracy, and 4, damages to plaintiff as a result of said acts. The gravamen of civil conspiracy claim is the underlying tort carried out by the virtue of the conspiracy, not the conspiratorial agreement itself. An actionable conspiracy requires an actionable underlying tort or wrong. The magistrate judge erred in concluding that plaintiffs failed to allege an actionable underlying tort. As shown, supra, the second amended complaint alleges that defendants conspired to commit violations of FDUPTA, the Lanham Act, and tortious interference. The tortious interference claim alone provides a viable predicate for conspiracy claim. As shown, supra, under Florida law, tortious interference, again, you know the elements we just talked about before. So the second amended complaint alleges that plaintiff maintained valid and enforceable business relationship with YouTube, whatnot, customers. Hale is alleged to have knowledge of these business relationships and to have intentionally interfered with them through false statements and coordinated conduct designed to harm plaintiff's reputation in business. The magistrate's conclusion that plaintiff failed to allege interference with specific business relationships overlooks the detailed allegations regarding Hale's role in the coordinated scheme. Hale initiated contacting contacted. It threw me off because of the way. Anyway, Preston and Cook and offered his assistance, joining the conspiracy to take down plaintiff. Hale contacted Manskin and others to enlist them as co-conspirators, labeled the effort the anti-whatthehales media ecosystem. These allegations, accepted as true, established that Hale intentionally participated in a coordinated effort to harm plaintiff's business relationship through false statement and reputational damage. Now, plaintiff alleged clear, positive, and supporting facts, specific facts supporting conspiracy. An agreement element of civil conspiracy may be established through an express or implied agreement. That's a thing too. So one thing, people think sometimes that there has to be an express agreement. It can be an implied agreement. Okay, so you don't have to have some written form or something that, again, this notes it. With 2 or more, each co-conspirator need not act to further a conspiracy. Each, quote, need only know of a scheme or assist in it in some way to be held responsible for all of the acts of his co-conspirators. Now, here's another case law also stating that the existence of a conspiracy and an individual's participation in it may be inferred from circumstantial evidence, and also confirming that an act done in pursuit of a conspiracy by one conspirator is an act from which each other is come jointly and severely liable. So, again, you see the layout to that. The layout there, it's not, again, some people, when they talk about those claims, they think that it's much more narrowly tailored than it is. But this means that the magistrate judge erred in characterizing plaintiff's conspiracy allegations as conclusory. The second amended complaint contains numerous specific factual allegations demonstrating Hale's participation in alleged conspiracy. Early in 2024, Hale appeared on the YouTube live stream with plaintiff and asked to collaborate on playing Legos. When plaintiff did not respond and instead collaborated with a competing YouTuber, Larry Foreman, Hale became upset. In retaliation, Hale contacted Preston and Cook and offered his assistance, deciding to join the conspiracy to take down plaintiff. Hale then took concrete steps to further the conspiracy. Spring 2024, Hale contacted Manskin and others to enlist them as co-conspirators, explicitly labeling the effort the anti-What the Hales media ecosystem. Hale invited Manskin to appear on Hale's YouTube channel. Manskin did so summer 2024, displaying their relationship as joint tortfeasors and co-conspirators for all the world to see. Since April 2024, Hale has made YouTube video publications that are part of the anti-What the Hales media ecosystem and replete with further false statements about Hale and Mr. Hales. The second amended complaint identifies specific false statements made by Hale. In one 2024 broadcast, Hale falsely stated that Jeremy Hales falsely claims he does not earn money off YouTube. November 15th, 2024, Hale appeared on Lee's YouTube live stream and stated regarding false signs about Hales, "I saw a picture of Jeremy Hales planting the signs himself. These statements are presented as factual accusations, not mere opinions. These allegations satisfy Florida's requirement for clear, positive, and specific allegations of conspiracy." Ooh, let me get a drink. Give me a second. A retaliation for being snubbed in favor of a competitor. Hale's overt acts in furtherance of a conspiracy, contacting Preston, Cook, and Manskin, creating What the Hales media ecosystem label, appearing on co-conspirators' channels, making false statements, coordination amongst conspirators, joint appearances, shared messages, mutual promotion, and unlawful objective, harming plaintiff's business through false statements and interference. A conspirator need not take part in planning inception or successful conclusion of conspiracy. A conspirator need only know of the scheme and assist in some way to be held responsible for all the acts of the co-conspirator. The second amended complaint alleges that Hale knew of the scheme to harm plaintiff's business and assisted in it by recruiting other plaintiffs, creating a unifying label for the effort, making false statements, appearing on co-conspirators' platform. These allegations are sufficient to support a plausible conspiracy claim. Now, the magistrate applied an improperly heightened pleading standard. The magistrate judge's conclusion that the conspiracy allegations are conclusory and lacks specificity imposes a higher pleading standard insufficient with federal notice pleading. Under Rule 8, again, this, I believe, well, I guess since this, under Rule 8, actually, this is a little bit different here than the other. A complaint need only contain a short and plain statement of the complaint showing that the pleader is entitled relief. While threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice, a complaint must contain sufficient factual content to allow the court to draw the reasonable inference that the defendant is liable. The second amended complaint goes well beyond conclusory allegations. It identifies for rehydration in the mini fridge. I've thought about putting our mini fridge down here, to be honest. We're going to read until 15 after, and then I'm going to power through Super Chats. I'm going to go, that'll give us a little bit more time. You know, we've gone 54 pages, which is amazing. You know, we're rolling. So I figure we can get pretty damn close to the end of this. It identifies the participants in the conspiracy by name, describes the formation of the conspiracy. That'd be Helm, initiated contact, President Crook, specifies the unlawful objective, harming business for plaintiff, and details overt actions in furtherance of the conspiracy, false statements, joint appearances, coordination, and alleges resulting damage. These allegations, accepted as true and viewed in the light most favorable to plaintiff, state a plausible claim for relief. I probably should. Yeah, that's one thing. Like a mini fridge would be pretty nice. Like a nice little water fridge in here. Plaintiff's claim against Helm is not without merit under Florida's anti-SLAPP statute. So the anti-SLAPP statute prohibits filing a cause of action without merit, and primarily because such person or entity has exercised constitutional right of free speech in connection with a public issue. It does so by prohibiting any lawsuit, cause of action, claim, cross-claim, or counterclaim against each person or entity without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with the public issue, right to peaceful assemble, to instruct representatives of government, or to petition the redress of grievances. I'm actually surprised, to be honest. I'm surprised more of them didn't file anti-SLAPP. That would have been my first move I would have gone with. That would have been. They'd have to hit me for that, because under that, it's your reading is fantastic at 2x speed. Heck yeah. That's the way to go. I've actually been going a little faster, but it causes as a Southerner, the speed I'm reading at is pretty fast for me. So that's why we have more incidents, I'm going to say, with pronunciation or enunciation. Such as shown, Supra. Plaintiff's claims have merit. The first requirement for anti-SLAPP protection is not satisfied. Second, magistrate judge erred in concluding that Helm's speech was protected under anti-SLAPP statute. The statute defines free speech in connection with public issues as statements that are protected under applicable law and made in connection with a certain enumerated context. However, false and defamatory statements are not protected under applicable law. The First Amendment to the United States Constitution, while providing robust protections for free speech in the press, do not extend to defamatory statements. This principle was articulated in here, where the Supreme Court held that defamatory falsehoods are not protected when made with actual malice. That is, with the knowledge of their falsity or the reckless disregard for truth when certain public officials or public figures. Florida courts have also consistently held that defamation is not constitutionally protected speech. For instance, the court reiterated that defamation is not protected under the First Amendment. Additionally, here's another case. The court explained that a connection is defamatory if it harms the reputation of another, lowering them in the community's estimation, or deterring others from associating with them. Further, Florida statutes reinforce this principle. Under Florida statute 836.09, knowingly transmitting false and libelous statements for publication constitutes a criminal offense. This underscores the lack of legal protection for such speech. Here is the footnote for that. It's talking about the communicating of libelous matters. That's all the rules to it. I'm not going to, this basically, it talks about the rules versus. So, I mean, this is just a dry recitation of the fact needed if you're going to make this argument, but I'm not going to read just a dry recitation of those, for timeliness' sake. It'll also, I think it'll kind of get us off track there a little bit. Similarly, Florida statute 770.02 provides that if a defamatory publication was made in good faith and corrected or retracted, liability may be limited to actual damages, but this does not shield knowingly false and defamatory statements from liability. So again, this talks about how you can actually correct that or apologize or retract something and how damages appear. Now, that's interesting how it works, but now this means that both the U.S. Supreme Court precedent and Florida law affirm that false and defamatory statements are not protected under applicable law. The Second Amendment complaint alleges that Hale made demonstrably false statements about plaintiff, including that Hales falsely claims that earned money off YouTube. He saw a picture of Hales planting false signs that defame him by himself. Such false statements are not entitled to protection under the anti-SLAPP statute. I'm surprised they didn't hammer this even more, with the things that surrounded that, or put it in context. I can only imagine through and again, we haven't gotten to the stage past just dismissal, but it would have been interesting to see how they try to frame that as. It's difficult beating those anti-SLAPPs, anti-SLAPP depending on the state. Now, Florida's anti-SLAPP, that's why I say, like, if you come at me at Tennessee has the second best anti-SLAPP rules in the nation. So to come at me here is pretty dumb because, a lot is upheld as free speech within Tennessee. California actually has the best. It's interesting how diametrically opposed these two places are, and yet how as far as the protection of speech, how they kind of line up. But a claim dismissed at the pleading stage is not necessarily without merit. The magistrate judge erred in concluding that plaintiff claim against him is without merit simply because the magistrate recommended dismissal for failure to state a claim. The without merit requirement under the anti-SLAPP statute is distinct from the Rule 12b-6 standard for failure to state a claim. The Florida Supreme Court recently affirmed this. A judicial determination that a speech-targeted lawsuit is without merit may not be possible at the outset of a case. It may require the development of a factual record. Wait, where is that? Did I miss the? That's a continuum. My bad. I saw this. I was like, where's that other footnote? But it's part of it. My bad. The purpose of the anti-SLAPP statute is to prevent meritless lawsuits filed to chill the exercise of First Amendment rights. The statute targets lawsuits that are both legally and factually baseless, not claims that are merely failed to satisfy technical pleading requirements. Here, plaintiffs have alleged that a coordinated scheme involving multiple participants. One second here. I got a message from somebody. Give me 1 minute. I'm making sure, like I said, if I get messages from family or something. I know, no derailment. People are like, hey, yeah, I'm plodding through without a lot of derailment. Usually on the weekends, if there's a huge item by myself, I can usually get through it. Usually I can't. Again, 58 pages. We're gonna hit 60 pages plus. That's pretty amazing. The statute targets lawsuits that are both legally and factually baseless, not claims that merely fail to satisfy technical pleading requirement. Here, plaintiffs have alleged a coordinated scheme involving multiple participants, specific false statements, concrete business harm. These allegations, if proven, would establish liability for civil conspiracy and tortious interference. The claim, therefore, has merit within the meaning of the anti-SLAPP statute, even if additional factual development is required. The underlying facts support a meritorious claim. The second amended complaint alleges facts that, if proven, would establish Helm's liability for civil conspiracy. Helm operates a competing YouTube channel that generates revenue through advertising, merchandise sales, and donations. After being rebuffed by plaintiff in favor of a more successful competitor, Helm retaliated by organizing a coordinated campaign to harm plaintiff's business. Helm recruited other participants, created a unifying label for the effort, made false statements about plaintiff, and appeared on co-conspirators' platforms to amplify the harmful message. These allegations describe actionable tortious conduct, not merely protected speech. The gravamen of plaintiff's claim is not that Helm criticized them or expressed negative opinions, but he participated in a coordinated scheme to harm business through false statements and interference with business relationships. Such conduct falls outside of the protection of First Amendment and anti-SLAPP statute. A plaintiff's lawsuit was not filed primarily because Helm exercised free speech rights. The primarily because requirement focuses on plaintiff's motive. The anti-SLAPP statute requires that lawsuits be filed primarily because the defendant exercised free speech rights in connection with public issue. Notice again through that's actually a Bongino. That's interesting. Anti-SLAPP is a lawsuit, cause of action, claim, cross-claim, or counterclaim filed against a person or entity that is without merit, filed primarily because the person or entity engaged in exercise of right protected by First Amendment to the United States Constitution. The requirement focuses on the plaintiff's motive in filing suit. A lawsuit is not prohibited by the anti-SLAPP statute if it is filed primarily because of tortious nature and harmful consequences of the defendant's conduct, even if that conduct involves speech. Here, plaintiff filed suit because the coordinated scheme to harm the business, not because Helm exercised free speech rights. The second amended complaint alleges that Helm and other defendants agreed to intentionally participate in the civil conspiracy amongst themselves with other individuals. The purpose which to commit violations. Again, we know all of the reasons. You've seen all of that. Again, it's fiducia, lanum, tortious interference. The complaint further alleges that Helm knew of the scheme and assisted in it, and he is jointly and severely liable for the acts of the other members of the conspiracy which were committed in furtherance of the conspiracy. These allegations demonstrate that the plaintiff's lawsuit targets the unlawful conspiracy and its harmful consequences, not Helm's speech per se. The fact that conspiracy was carried out in part through speech does not transform the lawsuit into one filed primarily because of protected speech. If it did, conspirators would immunize themselves from liability simply by using speech as a vehicle for tortious conduct. This would lead to absurd results and should be objected by the court. Now, the lawsuit targets tortious conduct, not protected speech. So the distinction between protected speech and actionable tortious conduct is critical. Yes, that would actually matter quite a bit. The First Amendment protects commentary, criticism, and opinion, but it does not protect false statements of fact made with knowledge of their falsity or furtherance of a conspiracy to harm another's business. The anti-SLAPP statute is designed to protect person exercising constitutional rights, free speech in connection with public issues, not to immunize tortious conduct that happens to involve speech. The Second Amended complaint alleges that Helm made specific false statements of fact, not mere opinion or commentary. Helm stated that Jeremy Hales falsely claims money again. You saw that. He also stated, I saw a picture of Mr. Hales planting the signs himself, which is alleged to be a false statement of fact, accusing plaintiff of fabricating evidence. The complaint alleges these statements are presented in a way that imply clear and factual accusations. Moreover, the complaint alleges that Helm's statement made in furtherance of a coordinated conspiracy to harm plaintiff's business. Helm contacted, you heard how all that works. That would be a coordinated scheme, and it would not merely be the exercise of free speech rights. So Helm's speech constitutes commercial speech outside of anti-SLAPP protections. Helm YouTube channel is a commercial enterprise. The magistrate, he erred in concluding that Helm's speech does not constitute commercial speech. The core notion of commercial speech is speech which does no more than propose a commercial transaction. However, speech may be commercial in nature when it's made in context of commercial enterprise and is motivated by economic interests. Helms operates a YouTube channel called Making Law Simple, where he refers to himself as the God of Law. Helm YouTube channel has made, I never thought I would read something with the God of Law. Helm's YouTube channel has an online store selling merchandise to viewers. Helm also seeks online tips and donations from his online viewers via Cash App. Helm has expanded and continues to expand substantial time, money, resources, etc., providing ongoing programs, etc., to get consumers. Let's see if there's anything else in there. We have 5 minutes, so all of the rest, let's see if it is all about anti-SLAPP. Anti-SLAPP. Give me 1 minute. Okay, so the next few pages, again, they are going to back up. I'm going to wrap up right here so we can hit super chats and start, everything the back of this. But you'll notice all of this is essentially about one person. Now, why is it about that? Well, because part of the recommendation was to give him reasonable attorney fees. He's the only one that filed anti-SLAPP. I said this beginning, my first move would be, that's like a typical first move. The problem, see, all of the ThATs and everyone, they think they're going to come up and get a payday from the case. Say the case, it goes badly, totally for Hales. As in, there is no more case going forward, and the recommendations are all taken. Well, they get nothing, because the ThATs and really the majority of the people on this, they never lawyered up. They did nothing that cost money. So for them, they can't expect anything in return. So they're wrong in that. And in fact, like I said, that federal case, it triggered a lot of other things that happened. Without it, you would not have the bankruptcy. You would not have some of the state cases, the way they fell apart either. I don't think you would have the unlicensed practice of law that transpired. There's a lot of stuff that was caused by it. But anyway, let's hit these here. We're going to run out of time here. But I wanted to really be complete in there. Hippie Witch, thank you. Gifted membership, kicked it off. Thank you very much, Hippie Witch. It is great to see you, and you are very much appreciated. Thank you there. Let's see. Fallen Hero, thank you for gifted membership too. Fallen Hero, how's it going, my friend? Good to see you. And as always, it's good to see you every single time. It's beautiful. Again, apologies yesterday, folks. I missed because I was, I had power at it, but I could have potentially, our power, I don't know when it established itself again, but I was just like, man, I'm not going to fight this whole thing. I did end up with power later on that night, though. Got to do stuff. I video gamed it up, which was fun. But I'd still planned on, it was the last day of the month. So I'd planned on getting it kicked out from there. Hey, Hippie Witch, thank you. There's an additional membership as well. So thank you. I appreciate you all with memberships too, because memberships they're not just a thing that helps the channel. They help others as well. And I appreciate that. Max Lab, how's it going? Thank you for the super chat there. Appreciate you. Appreciate you also sending over documents, helping out with things. People check out Max Lab's channel. He is working on his watch time. Watch time is the most difficult portion to gather when you're trying for monetization. Sister Sal dropped 5 giftos there. Thank you, Sister Sal. I appreciate that. That is awesome. And like I said, giving to others too, that's equally great. What's up, Hazel Monte Ingle? I love, like, some names I don't say all of it. Your name, I almost have to say it all together. I love it there. Thank you for the 5 giftos there. Appreciate that. Love the little avatar. It's cute. I love like family avatars too, Sister Sal. I love some of the cute avatars. Appreciate them. What's up, Audrey? I said Audrey. My brain. Thank you for the 22 months. Appreciate it. So much fun watching the What the Hell circus brief what they're sewing. I am entertained. Much love always. Indeed. You know what's really funny about all this too? If everything were to end today, they would just effectively disappear. They have nothing beyond it. Like most of their main players, what do they become? They become nothing. Like I said, the Fats, they are so awful to listen to that they will never become a big YouTube channel. They've managed to ride this to the point where they may put themselves in jail with it, but without this, they amount to nothing. And that, to me, that's amazing. It's like these people, they don't realize they need Jeremy Hales to also, file a lawsuit and other thing, because, and if it were just words and more, then Hales could just ignore them. But the problem is they don't go with just that. They do crazier and crazier things as response. So, but yes, I'm very entertained by the stupid. And thank you, Audrey. Appreciate you. SF, thanks for the 2 there. Sure, Tug. We know it was a Resident Evil holiday. Oh, it was. But, by then I'd already beaten the game. So that doesn't mean I haven't played it a second time. That game, it's like this. I was going through, so we have just on the PS5, we have Resident Evil 4, the remake, right? But we have it in multiple other things. But with the kids, myself, we play it together, run through it. They goof off, like the oldest just runs through. But I was looking at how much time had been spent playing that game. And that game by itself, just on the PlayStation, has 527 hours. I was like, good Lord, that's a lot of hours, because the kids are they like to play like some of the zombie games and stuff where they attack you. It's so funny to watch them. But yeah, it has been one for sure. Maureen, thanks for the 18 months. I missed my tug fix last night. Oh, sorry about that. I like I said, I can't remember the last day I took a day off either. That's really weird. It was so bizarre. Shifter, what's up? Hey, what's up? It's 73rd birthday. That's awesome, man. I have no idea where that 2 came from after my name. Don't know how to get rid of it. You have to change the @ you can rename your YouTube. You can do it one time. That's your @ part. So when you first named your channel, it just automatically assigns you an @ but you can go in, look up how to change your YouTube name, and you can do it one time, like that. But more importantly, here we go. Happy birthday. Happy birthday. From both of us to you. Happy birthday. Happy birthday. May all your dreams come true. Happy birthday. Happy birthday. We love to have you here. Happy birthday. Here's to
year.
Man, appreciate you too, my friend. But yeah, check that out. Again, Cynic, appreciate you, my friend. You know, again, love to your family, love to you guys there. It's rough, man. Hate to hear about that. You know, those loss anyway, but man, young like that, man. Like I said, love to you. Everybody keep Cynic and his family in your prayers for sure. Appreciate you, brother, very much. Cynic also, thanks for the 2. It confirms the antis are not PDF files. They hate kids. Indeed, they are not. Nor has anyone actually been accusing them of it. You know, that's the funny thing is these people, they really like to whip out those allegations. You know, they go with some of the worst allegations possible. Other people are like, they hate kids too much to do that. Hey, what's up, Cindy? What's up? Thank you for 60. Yay, that's awesome. You know what that means too?
Happy birthday.
It means you get that birthday song. That's
Both of us to you.
I love it.
Happy birthday.
May
May all your dreams come true.
Happy birthday. We
love
to have you
here.
Happy
birthday. Happy birthday.
Here's
Here's
to
to
another year.
Oh, give me 1 second here. Well, dude, like I said, you know, we kicked that off. Good, fun times. 1 second. 1 minute. All right, there we go. I had to something out. Rosalind birthday stream right too. Look at that. We got a few in there. Bam. Bam in there too. Hello. Oh man, we got 2 more coming in. That's awesome. So Rosalind, man, that's great too. Let's kick out a birthday wish for her. Appreciate her too.
Happy birthday.
Birthday, Rosalind.
From
all of us to you. Heck yeah.
Happy birthday.
Happy birthday.
May all your dreams come true. Happy birthday. We love to have you here. Happy birthday. Here's to another year.
Man, Marla, by the way, Marla trying to hire somebody to put up a post asking for somebody to organize their 8x10 craft shed. So they're paying them $50. Man, $50. Lord, that sounds like more work than $50, doesn't it? E. Poindexter, thank you for the gifted memberships there. Drop 5 there. Thank you, E. Poindexter. And it's great to see you as always. Love it. I always like that last name too. You know, I always like how it rolls together like that. Sherry, thank you for that 5 gifted memberships as well. Look at that. 10 giftos dropped all together right there. Man, both of you, Sherry, Poindexter, appreciate both of you. It's awesome. I love it. I love seeing them hit, you know, and gift to other people. It's great. Look, William, thanks for the 5. Enjoying your stream on my birthday. I thought the first was on Monday. No need for a song if you don't want to. Well, you know, there's always a need for a song.
Happy birthday.
It's your birthday, baby. That's right.
From
all of
us to you.
We gotta have that. Happy birthday. Happy birthday.
May all your dreams come true. Happy birthday.
Happy birthday.
We love to have you here.
Happy birthday. Happy birthday.
Here's to another year.
Heck yeah. Always need that birthday song, man. Always. And appreciate you, my friend. Just Jay. Man, you know what really stuck with me to this one is the insinuation that Just Jay's accent is possibly supposed to be Southern. I can't hear it. This guy's voice is a fake Southern accent, nearly worse than mine. Is that, or is it supposed to be a fake Southern accent? I'm not sure. Caroline, thanks for the 10. With the whole thing in regards to the customer relationship, doesn't that mean BBB and some of them have that relationship with what the Hales because they're members and get things from whatnot as well? Yes. The just grouped as, yes, that would make them have a relationship. If they do that, they would be part of it, and that would be the whole thing. Like some of these antis that, you know, they were told things like, oh, well, you know, Hales tried to take out these 2 dogs, blah blah blah, you know, obviously things they said they were going to prove, by the way, and they never did. And you can imagine how damaging claims like that would be, you know. So destroying existing relationships, you know, some of these people that went anti, you've also had people come forward and talk about how, like the bench donor, for example, that did the interview, the 1K bench donor, that person, they said that these things, they didn't, you know, they listened and they ended up donating to these people because of, and it was because of allegations against Hales. Because they believed them. Because who would think that someone would make up that kind of crap, right? Crazy. What's up, C Mac and Cheese? Appreciate you. Thank you for that super sticker, by the way. I appreciate that. That's a cute avatar, too. I love it. Thank you. Bong. 70 pages of coping and seething. Another L inbound for Jeremy and the failed Dennis Lawyer, Randy. Well, thank you. Appreciate it. I wish we would have gotten all 70 pages, though. Like, man, I thought we gave it enough time. God, that's a lot of pages. I'm shocked we got through 62, you know? And thank you for the 5. You know, again, the one thing that people should not be required to do is to agree with filings either. You know, I personally, I think that the things that have been done within the ecosystem, again, it runs both ways. If damaging reputation and more is not a problem, okay, well, that's cool. It's funny because these people threaten the same type of lawsuits against Hales, really, and everybody, including people at Facebook and more. So it'll be it's craziness, isn't it? But yeah, thank you, Jack's mom. Thanks for the 5. It's hard as to serve anyone without any help from the judge. He should allow them to amend it. It might take another year to serve them all again. He should. I mean, with prejudice is a pretty harsh hammer to drop, you know, and you typically are allowed to go in and to amend complaints. That's something that even with the cases that Bolito himself quotes, many of those, like the ones for proof for, you know, for saying that this is wrong or whatever, they were dismissed with prejudice. I mean, without prejudice. I said without prejudice. That meant they were allowed to amend. So the very ones he claims, like, hold up, again, I think he wants this thing away from him. I think he wants this case gone. You know, all of these players, unfortunately, you know, when they think that, the judge, when he's doing that, he may be getting away from himself, but he's still, it's self-serving, if that is the case. I guess that's the best way to go. Cynic, thanks for the 5. If they get it downgraded to dismissal without prejudice, I suspect Jeremy might go to state court instead of filing another federal lawsuit. Yeah, I think, like I said, I think you pick off certain people if you want to go with that route. I think you see how bankruptcy takes its course with certain folks, because I think it's going to wreck them. And then after they take that hit, then you get him again. I don't think Hales doesn't strike me as a person that's going to let people like the Fats walk away. You know, not after again accusing him of SA and more. Like some of these people, I mean, the idea, like they do understand that one case, like they're complaining, they're like, oh, the judge should do this or that. It's been one case that's been dismissed if it goes that way. One. So you can be sued again. They were all cheering that idea when Lips. See, I have no sympathy for any of them. When Lips did that, like to myself, they all cheered it on. They were like, oh, a second time. Ha, 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 ha. So fuck them, you know. If they end up, and you actually see where claims, you would see where claims potentially would need to be, I guess, more succinct. Like you couldn't bring those specific ones, but you can bring other things. And there are some other things against specific people. Like again, 2L has got some bad stuff that could be hit. I think that would mess her up. Think and believe. Thanks for the bomb there. The what the hell's ecosystem and BBB's behavior in these cases are a classic case of heckler's veto. Heckler's veto. Let's pull that up. There's veto. Let's describe it there. Definition. A heckler's veto occurs when a speaker's exercise of free speech is silenced or curtailed by a hostile audience's disruptive actions or by government censorship in anticipation of such a reaction. It violates the First Amendment, which protects the right. I'll have to look it up. See what's what with that. Give me a second. I'll look that up. Thank you. Appreciate you, my friend. Cynic in Chief, thanks for the 2. The SA false claims against 2L and Lips are solid. Yes. With them, well, see, what's really crazy with 2L, they think that you repeating a claim somehow gets you out. You know, well, I didn't manufacture it, but even worse, they stated that they conspired. So she helped create that claim. So bad luck for that. I think that one's a really solid case against them for sure. Polar Spark. I wish Jeremy would get a TPO, which can be granted for false SA claims in Florida, then go criminal. Yeah, I think, currently, I actually think with Hales, he's probably feeling like law enforcement will never help. Like that, it's an unfortunate statement with that, but I bet you he feels like that. I don't know that for certain. I'm not saying he does for certain, but look at the lack of law enforcement help with any of this stuff. You know, even with, he's got a protective order. What is that amounted to? You know, it's amounted to nothing, a whole lot of nothing. And that's kind of, there we go. Let's see. I'm putting my redirect in. But you probably also, I bet it lives and violated within 12 hours. Yeah, depending on where in the cycle. I think that would be true, man. I think so. Also with Caroline, thank you for taking on the Trading Post thing as well, so that Travis or Willis can continue doing fun things. And indeed. You know, I noted that before, but I do. I think that he deserves more. You know, more just to have fun. This is not his fun. Like my fun is going and making fun of weirdos online. I think it's, that's my fun times. It's not his fun times. His fun times is something different. And Polar Spark, thanks for the 5 here too. Travis wants to stay positive and build people up. So he wants to leave it where he's made it very clear, that he doesn't enjoy the chaos. Like I said, I enjoy it. I will never claim that I don't. There are people out there like the Fats. What kills me about them is they're like, oh, we don't do it. We don't do this. Come on, man. Just embrace it. Embrace your stupid, because they are. But yeah, he just wants positivity and to have a little bit of fun, you know. Rosalind, what's up, Rosalind? How you doing? Thank you for the 5 giftos there. Thanks, Rosalind. That's much appreciated. Thank you. Me too. Thank you for the 5 there. For your rehydration and mini fridge. Woohoo, baby. That's one. Actually, I have thought about one for real. Like I was saying before, I've considered it. I don't like those tiny ones, but I like the ones that are about as tall as like a little kid. Those are pretty good. Jody, thank you again. Your reading is fantastic at 2x speed. Well done. Thank you. Appreciate that. Yeah, I speak slow enough that 2x usually you could probably even go a little faster than that. It's fine. Esha, thanks for that 20 there. Money for a beverage fridge. Heck yeah, baby. Get that mini fridge on. Appreciate you. What's up? See mac and cheese. Thanks for the 5 there as well. Mini fringe fun. We need a hydrated tub. That's right. I've been drinking a lot of water compared to before. Like I said, one of my huge feelings was that I did not hydrate well. If I've learned anything, it is to hydrate. I drink a lot of water. Andre, thanks to the 2 there for an old box to hold your warm drinks. That's it. Here's some cardboard, sir. That's funny. Okay. Hey, here's your daddy. Thanks, 5. My birthday wasn't today or yesterday, but I became a year older in the last 24 hours. When is my birthday? Your birthday is on February 29th. Leap year. You're a leap year baby. Is that true, by the way? Who's your daddy? Is that actually true? I'm going to bust you up a birthday song. And if it was just a riddle, that's awesome. But if not, I'm going to bust you up a birthday song anyway. Because I've always thought leap year birthdays would be so odd. Like, when do you celebrate? Like, when people get together, do they celebrate for the last day of the month? Because, your birthday is it's always in that month. It's just not on that specific day unless it's a leap year. So I'm curious about that. But here,
happy birthday.
Happy leap year birthday.
From both of us to you. Happy birthday.
Happy birthday.
May all your dreams come true. Happy birthday. We love to have you here. Happy birthday. Here's to another year.
Happy birthday, my friend. That's good too. I like that. If you would have asked me that just at a random time, I probably would not have. I would have been like, but it just hit me with that otherwise. Sailor Dark Jupiter, thanks for the 2. It's because Megan's not here to derail you. Oh yeah, that I get through 60 pages. Actually, I derail myself really badly sometimes too. It has to be a perfect storm. I have to not derail myself, then no one else derails me either. I also just wanted to get through that document today. I was like, man, it's a lot of document. I like to go through them, and like I said, I like to be completionist. That way, it's these people who claim that they cover cases. See, this is the thing that kills me about the ecosystem. They claim that they're just out there covering a case or doing this or doing that, right? But they never look at documentation. Even if a document is helpful to them, they don't review a whole document. They pick and choose. Part of covering a case is to inform people of what exactly is transpiring. And it's also, it teaches you how law works. That's why you can tell, like these documents these people are filing, they're not writing these documents. You know, maybe one of the reasons they don't read anything there is because they don't understand any of it at all. And I'm not saying there aren't parts where, you know, like I'm not a lawyer, nor do I ever pretend to be a lawyer. But Lord, if you cover it for a while, you pick up some of this. You know, you understand some of it. But these people, I think if I were younger, I think I would potentially go and take law classes or something to just in furtherance of all this. I don't think I'd ever want to practice law, but I think I would enjoy going in and learning more with law. You know, I think it'd be interesting just to, you know, go in, learn a lot, pass the bar, so you can be like, ha, 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 ha. But I'm too. That's a lot of years to set in my old age. You know, I don't feel that motivated right now. Wheat Toast West Coast, my friend. How you doing? Wheat Toast, baby. Thank you for the gifted membership. Good to see you, too. I always enjoy a Wheat Toast signing. Mark, what's up, Mark? Thank you for the 5 there. Hey, Mark, by the way, I appreciate all your postings and stuff. Again, if you want somebody good to follow that does that clips out, like again, many of the transcript clips that pop up, one of the people that really does good posting with that, one of the few that, you know, has been taking and again directly referencing and posting, Mark there. So if you haven't followed him on Facebook, you definitely should. And there's a few groups out there that are actually really good with postings too. You should check them out. Sure, thank you. Give me a second. There. Sorry, I went to say your name and I started to clear my throat in the middle of it. I was like, no. Sherry, thanks for the 4 months. I've been watching you longer than 4 months, but I'm a late bloomer on joining. Oh yeah, I know you've been here much longer than that, but appreciate, again, that's not your viewing day. That's when you were like, hey, you know, I've been backing since X date. And thank you for that. That's much appreciated. Uriah, thanks for the 2. The mods were worried we engaged to find you. That's funny. Yeah, we just had like I said, powers. I was I don't know if he messaged. I may have not even noticed it too. I can't even remember. I can't even remember the day, but I do appreciate it. Yeah, he always checks in and stuff. If there's something there, the mods are great about that too. If I don't show up for something, the mods are like, "Wait, what the heck?" Well, you are good. You okay? And I do appreciate that. Oh man, Hale, that's I buried my mother today. Listening to you, it lifts my spirits. Well, you know what? Love to you. Those times like that. Remember that after something like that, that it's okay. First of all, it's okay to mourn. It's okay to deal with it how you deal with it. And it's okay to laugh. It's okay to enjoy yourself. It's okay to have moments away from that feeling too. So love to you, appreciate you. And, you know, join in, goof off with us. Like I said, you know, you're always welcome there, and love to you for real. You know, much love to you. Those are difficult times, man, but it does feels better when you can find something, you know, to divert your mind a bit and just do something else, you know, but love to you. Heather, thank you for the 11 months there, almost a year there. Not a statement attached, plenty of statement though. Thank you. Appreciate you. Amy, thank you for the super chat there too. Again, doesn't have a statement attached, but backing is its own statement. Thank you. Appreciate you. Pickle Tank, thanks for the 20 there. I have a mini fridge in my bedroom. I ordered one from Walmart, delivered in 3 days. I have a microwave in my den, still in the box. That's coming here next. It sucks not being able to walk. Well, it's got to be nice to like have your like set up like that. That's got to be good. But yeah, you know, I appreciate you. I like the suggestion that people like. I've had 2 people mail and be like, "This is the refrigerator. You probably should try one like that." It's pretty good stuff. All right, I'm gonna go ahead and we've got the redirect set up. Hales goes live in like 15 minutes, so you should have plenty of time for that. Isn't the umbrella man the insurance salesman? The umbrella man can. That's funny. Yeah, Pickle Tank, man. You know, love to you. Appreciate you. You know, man, so many people out there. One of the things I notice with all of us is that there's so much that goes on in the world and so much that goes on individually. But it's great to be able to get together and take a little bit of that off, you know. But I appreciate you folks. We will see you tomorrow. Bill and Megan, go check out Hales. We'll see what the fun actually conjures up. And appreciate y'all. See ya.